includes, it does have a chimney with gas logs inoperable at this point, but electricals. It can't be moved. It would have to be demolished and rebuilt 30 inches closer, further away from the side property yard. There's no way to reconfigure it. They've looked at this, and it just needs to be demolished, completely demolished and rebuilt. As Mr. Thompson points out in his affidavit, that would also necessitate damage to, the pool itself and the pool decking. Next slide, please. When it became evident that, in fact, there was an encroachment, and in an effort to appease the adjacent property owner and to try to mitigate any impact from the encroachment into the side yard by 2.5 feet, Mr. Talibi investigated various options, including, trying to reduce the width of the rear wall of the pool house. He did offer to reduce the height of the chimney to the extent allowed by the fire code. He also offered to provide screening behind the pool house, and all these offers were rejected. The only offer was to demolish the pool house and relocate it at least 20 feet from the side property line. Next slide, please. In an effort to mitigate the impact of, or any impact related to this encroachment, Ali and Sanaz have recently spent approximately $5,000 in landscaping. They've provided 6-foot tall trellised magnolias that will grow approximately 1 foot per year in order to help screen the pool house. They recognize that if they are asked to demolish the pool house, that would be $5,000 they will lose, but it was important to them to show their commitment to their neighborhood and to this board. Additionally, in response to the neighbors' concerns that this pool house appearance or encroachment might negatively impact the value of their property, Ali and Sanaz commissioned an analysis report from an MAI appraiser familiar with the area. That is Damon Bidencope, and his affidavit is Exhibit 7 that was submitted to you. He actually lived about 450 feet from this property at one time, and it is his opinion that given this neighborhood where accessory uses are commonly found abutting adjacent property lines, no impact. This encroachment would not have an impact to the adjacent property. And then I think one more slide. That's again the trellis. You can see the trellis that the magnolias will grow up the side of the wall there. These are currently 6 feet. And I think that's the end of our photographs. As the applicant, we recognize it's our burden of production to provide competent material and substantial evidence with regards to the 4 standards of the variance. We have demonstrated that strict adherence to the ordinance would create an unnecessary hardship, practical difficulties. Relocating this pool house by 30 inches will require total demolition of the structure, as well as damage to the pool and surrounding decking. This hardship resulted from part the sloping topography and resulting L-shaped house intended to take advantage of this long, narrow lot. The hardship was most assuredly not the result of the applicant's actions. Ali and Sanaz going beyond what the average property owner was going to do to ensure their redevelopment complied with all zoning regulations. The ordinance specifically allows for variances in situations where mistakes are made. This is best efforts. And yeah, there was no attempt to circumvent the ordinance requirements, but we are seeking relief from them. As such, the requested variance is consistent with the spirit, purpose, intent of the zoning ordinance. The purpose of side yard requirements is to provide adequate separation between structure in the event of fire, or to prevent one structure from depriving another structure of light and air. Allowed to remain where located, this pool house is not going to present any increased fire hazard to the adjacent property, deprive another structure of light and air. To this end, public safety remains secured. Substantial justice is also achieved by granting the variance when one weighs the damage and expense caused by moving the pool house versus any benefit an adjacent owner may receive by having the pool house 30 inches further from the adjacent property line. Screening has been provided to mitigate any perceived or otherwise impacts. We are respectfully requesting, and we're tendering Mr. Perry and Mr. Thompson and Mr. Bidencope and Mr. Hoffman as expert witnesses in their respective fields. And we would ask that you accept, to the extent they make provide any opinion testimony, that you accept them as experts. And we also offer exhibits 1 through 8 into evidence. And again, Mr. Thompson, Mr. Perry, Mr. Hoffman, as well as Mr. Bidencope are here in addition to their affidavits, and they are available to answer any questions. Mr. Talibi has also submitted an affidavit. He's very emotional about this and felt more comfortable submitting an affidavit, but that has also been provided to you as, I believe it's Exhibit 3. Thank you very much.
All right, thank you. I have a question. So you said that before everything started, Mr. Talibi, I understand the difficult situation that he's in, and I have empathy for that. But my question is, you said before everything started that there was had an attorney, I think what you said, Mr. Hoffman, reviewed the zoning requirements and made sure that the plans for the house that were designed met all the zoning requirements?
That is correct. There were 2 reasons for that. Number one, that Mr. Talibi had received a email from a neighbor, maybe perhaps across the street, regarding, just an alert, a general, hey, we have zoning regulations here as well as private deed restrictions. There was also a letter that the Myers Park Homeowners Association sent, notifying, just sort of a form letter notifying new property owners that there are in fact deed restrictions. The second reason for asking Mr. Hoffman to review is it's actually a requirement of Mr. Perry's contract that the property owner obtain a legal opinion that his plans are in compliance.
Okay. So Mr. Hoffman knew that the zoning requirement required a 6-foot side yard?
No, I believe that Mr. Hoffman is available to speak, but my understanding is it's just the confusion over, when you look at the pool and you look, it's in the backyard. It's in the backyard and the pool house is in the backyard, and there was a confusion over interpretation of the rear yard versus the backyard. It was I guess, Mr. Hoffman, if you would like to address that, probably speak better.
Yes, can everybody hear me?
Right. And you're a attorney?
Yes, sir.
Okay. please state your name and address for the court reporter then.
My name is Ryan Hoffman, and my address is 1420 East 7th Street, Suite 100, Charlotte, North Carolina, 28204.
Okay. So my question, I mean, if you reviewed the plans and, or the covenants and the zoning ordinance and the requirements for the Myers Park and everything, and the zoning ordinance said 6 feet, then why were the plans, why did you give the go-ahead for plans that showed full house to encroach into that 6 feet?
Sure, and this is where the confusion arose. Personally, and I have all the respect in the world for the zoning board. I've worked with them, not the zoning board, but the zoning administration. I've worked with them quite a bit in the past. But the confusion arises from the language that states that it has to be to the rear of the house. From the rear of the house, it's a 6-foot side setback. And as we discussed, this is a unique L-shaped house. And so in my analysis, I deemed that it was the rear of the house. In no way does the zoning code say the absolute rearmost point or the rearmost point. It says the rear of the house. I mean, that's unquestionably the door that opens from the back part facing the street is unquestionably a back door. And so the purpose of having the decreased side yard to the side of the home is so that you don't have the home and then directly next to the home an accessory structure and all of that crowding onto the neighboring property. But here we didn't have that. So I believed that to the rear of the house meant behind the house. So this is behind the main portion of the house. It's not behind the rearmost portion of the house, which is that L-shaped, which shows on whatever exhibit number 7, which shows as touching the established rear yard. And so from my perspective, the pool house, it is behind the main house. It is, and therefore subject to the 3-foot setback. And I was unaware that zoning's interpretation of rear setback is that it is from the absolute rearmost point of the principal structure. And so I believe that's where the confusion arose.
Well, wouldn't that have been worth a phone call to Mr. Spencer to get his interpretation?
Yes, in retrospect, I could have called Mr. Spencer to get his interpretation. However, I believe that it was behind the principal part of the house and therefore wasn't subject to that 6-foot setback.
And then that was just the first step that just compounded during the construction and to get us to where we are today.
That is correct. Just one step after the next step. Within the building permit confirming Mr. Hoffman's position.
Okay. Are there any other questions for the applicant from the board?
Are there any questions for the experts?
I don't have any questions for the experts. I don't know if the rest of the board does.
Mr. Chair and Ms. Todd, at this point, I'm hearing you refer to your potential witnesses as experts. I think for the record, I would like to just ensure that the testimony reflects them being tendered as experts. And so to the extent that you want to highlight their affidavits, I think that would just strengthen that designation. Ms. Todd.
Thank you.
Thank you.
Ms. Leslie Fight. I will, as I mentioned, Mr. Greg Perry is a designer and former licensed, he was a former licensed contractor, but he is the owner of Perry Design with over 15 years in custom home design. He has actually designed several homes in the Myers Park neighborhood. He served as designer for this building project, and with that, I would tender him as an expert in custom home design.
Any objection to that? Mr. Chair, would you accept that? Would the board accept Mr. Perry?
That's fine with me. I don't I'm
Okay.
fine with them. I don't really have any questions for him, so I don't know if the rest of the board does. I've got my question that I had from the presentation answered so far.
Okay, and Mr. Thompson is a licensed general contractor. He is founder of Thompson CBT with over 10 years experience in custom home building. And he also has built homes in the Myers Park area. We would ask to tender him as an expert in custom home building.
It's fine. I don't think that's prudent for this case, for this board to have witnesses classified as experts versus just regular witnesses. Am I incorrect, Ms. Wright?
So the reason for that, if they're providing testimony that this board is considering to be specific to a field of expertise, particularly one that requires licensure, it would be prudent for the board to designate an expert because in fact it does help with the analysis of substantial, competent, and material evidence. And so that was the reason for highlighting that.
Okay.
And we have one more that, if I may, Mr. Damon Bidencope, and he's an MAI appraiser. Well, he carries the MAI designation. He has been practicing, he's licensed North Carolina real estate appraiser, has been practicing in North Carolina for over 25 years. He is the owner of Bidencope and Associates, and actually lived within a stone's throw of the subject property. Very familiar with the Myers Park area, as well as currently lives in Eastover, approximately 8/10 of a mile away. And we would ask that we would tender him as an expert witness in real estate evaluation.
Okay. Sorry, you were muted there, Andrea.
And
Thank you, Ms. Todd, and thank you, Mr. Chair.
thank you. I have nothing further. If the board has no more questions for us.
All right. Are there any questions from the board members for the applicant? All right. Hearing none, then let's.
I'm sorry, Rick. I do have one. I understand the initial confusion, but when we went to permitting, there must have been still confusion because the permits approved that they submitted and were approved by the zoning approved the 3 foot, correct?
Correct. Well, they provided for left, right, 3 feet. So,
All right. Thank you.
thank you.
Okay. Any other questions from the board? Mr. Brown, Mr. Welch, Miss Allen?
None for me right now.
None from me.
Okay.
No.
Then Mr. Spratt, will come back to you. Do you have any questions for, or I guess staff, do you have any questions for the applicant?
No.
All right, then we'll open it up to parties that want to speak for or against. So Mr. Spratt, you're up first. And you can ask questions of Andrea. I guess he can ask questions of either party. Is that correct?
Yes, sir.
All right. So Mr. Spratt, please go ahead and state your case, and please be brief as you can be, so we can get this moving forward. Because we have other speakers behind you, so. And if you're talking, you're muted, Mr. Spratt.
Can you hear me okay now?
Yes, sir.
All right. I'm going to go as quickly as possible. There's a lot of information I need to cover, and I'll do it as best I can and as quickly as I can. Again, I'm Gilly Spratt. Some of the records referred to me as Robert Spratt. I'm a retired lawyer. I was in a small firm. Since my retirement, I'm a part-time mediator where I try to help people resolve disputes. My wife, Beth, is in the room with me. She's a former elementary school teacher in the local system. We moved into 2601 Hampton Avenue in 1982. It has 2,500 square feet heated. And until November 27, 2017, the 2609, where the Talibis live now, was owned by the Deals, and it had about 2,700 heated square feet. My testimony is going to consist of going through the exhibits that I submitted last week, and Max has indicated that he'll be able to pull those up as I call for them.
Mr. Spratt, I'm sorry to interrupt. And Mr. Chair, I know that Mr. Spratt is an attorney, but he's providing testimony in a factual capacity. So I would just ask that he would affirm his testimony to the extent that it's testimony, as opposed to, I guess, acting in his capacity as an attorney, perhaps. But I just think it would be appropriate to have him affirm his testimony. And I apologize for interrupting Mr. Spratt.
That's okay, but I actually, earlier when they asked for witnesses to indicate yes for being sworn in, I said yes at that time, but I will affirm it again now.
And thank you for doing that, Mr. Spratt. We will be doing that with the subsequent witnesses, because in our virtual format, we just couldn't see folks and be able to distinguish between the two. So we'll be doing subsequent witnesses. But thank you. I appreciate that.
Completely understood.
All right, then do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right, thank you.
All right. If I can get Max to bring up the exhibits that I submitted and go to page 1. You can skip that page. Okay, go to page 1, if you would. Okay, there you go, page 1. Can everybody see that? Can you see that okay, Mr. Sanderson?
Yes.
Okay. Well, what I've done on the exhibits, in order to save time, I've done some green underlining and some yellow highlighting in hope that it will draw your attention to things more quickly. One is just section 12.106, which provides that no accessory structure shall be located within any setback or side yard required of these regulations. It also provides that no accessory structure shall be located within any established setback in any residential district. And then Max, if you'll go to page 3, this is table 9.205 from the code. And I highlighted there with green underlining the maximum 6-foot residential setback for side yards. And right above that, you'll see that the minimum setback from the street right-of-way for prior to 2010 is a 30-foot setback, and 27 otherwise. And then if you go to page 4, this is section 12.405, and subsection 2 provides, begin quote, no fence or wall located in the required side yard between the required setback and established rear yard shall be built to a height greater than 6 feet above grade, end quote.
I would object to any references to fence or wall. We had had this conversation earlier where Mr. Spratt has indicated that he wishes to bring up alleged zoning violations that are not before us today. And we would object to any other references and ask the board to keep with the matter at hand, which is the violation of the encroachment.
Noted, Ms. Todd, that's correct. We're only dealing with the encroachment into the side yard with this case. Any other infractions, if there are any, would need to be identified by staff and then dealt with at that point in time.
All right. If we can now go to exhibit page 5. This is a survey that was done for Mr. Talibi on October 15, 2019. And this was a survey by Eric Clemmer, and it's attached to the variance application. So it's one of Mr. Talibi's exhibits. And it's interesting in that you'll see where I've highlighted that it shows the 6-foot side setback, and it goes right through the pool house. So this survey on October 15, 2019 demonstrates that part of the pool house is in the required side yard. At the time of this survey, the pool house was still under construction. I actually had a discussion with the surveyor that day because he wanted permission to come on my property, which I gave to him, and he and I walked to the back of my property together. But in any event, this was before the pool house was completed. It was before any of the attachments had been placed on the back of the pool house. It was before the stucco coat had been placed on the pool house, on the back of the pool house. It is one-dimensional. It does not show heights, not that that makes any difference. But it was at a time that you still had scaffolding on the front and back of the pool house. If you'll then go to page 6, this is a survey that I had commissioned. It was prepared by a surveyor named Daniel Wooten, and this was prepared on February 24, 2020, which was after everything had been completed on the pool house. It was after the attachments had been placed on the back of the pool house. And again, I would refer to the glossary terms in the zoning packet that indicated there's an exception to the hearsay rule for technical reports from experts such as engineers. So this should be an admissible item. If you go to page 7, this is the same survey by Mr. Wooten, but I did some green handwriting on it to basically make it easier to follow. You'll see where I circled, it says EB 2.9 feet. EB, under the legend, is an electrical box. There are actually multiple boxes and attachments on the back of the pool house, but this particular one, I asked him to survey one of them, and I'll show you which one on a photograph. It goes within 2.9 feet of the side property line. So that's the case. If you'll also note what Mr. Wooten indicated at the back corner of the pool house, he indicated that at the part of the pool house closest to Hampton Avenue, it was 3.4 feet from the side property line. And at the side of the pool house further away, it's 3.3 feet from the side property line. And I'm confident that the reason that this is a little bit different than Mr. Talebi's survey is that this was after the stucco had been placed on the back of the pool house. That was not there when the surveyor for Mr. Talebi did that survey on October 15. If you go to page 8, this is a photograph I took on February 7, 2020. And I took it that day because Mr. Talebi had two contractors out there working, and it puts the pool house and the wall in perspective. So if you'll then go to page 9, this is just taken from the edge of my driveway, but both surveys indicated that the wire fence, and the wire fence was owned by the Deals. It was actually on the property line, and the surveys indicate it was on the property line. So this helps show that just how close the pool house is to the side property line. It puts it in perspective. If you go to page 10, this is a photograph I took in June 2020. Mr. Talebi had the wire fence removed, which I applauded him doing so. But again, this just shows the various attachments to the back of the pool house. And the lowest of those 4 boxes is the one I had the surveyor survey. And so that box comes within 2.9 feet of the side property line. If you go to page 11, this is a view of the pool house taken from my yard, which just gives you a different view. And then page 12, again, this is just sort of a wider view because I was trying to show the wall too. In terms of, well, strike that. To Beth and me, it's not just that the pool house itself is so massive and so close to the property line, but the attachments to the rear of it also we consider to be unsightly. If I can then get you to go to page 13. This is section 5.108, the standards for granting a variance. And they have to meet all four of them. And subsection 1A reads, the first sentence reads, begin quote, unnecessary hardship would result from the strict application of the ordinance, end quote. That's a very subjective standard, and I think your answer to that will depend upon your answer to B, C, and D. So if you look at subsection 1B, it reads, begin quote, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances and hardship, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance, end quote. So I think one consideration is what is meant by peculiar to the property. Is it talking about property in the sense of land, or is it talking about property in the sense of land plus structures? There's no definition of property in code. If you'll go to page 13A, this is the definition of property by Merriam-Webster dictionary, and it indicated synonyms for property, and the ones it listed were lot, parcel, plat, plot, and tract. If the term peculiar to the property is interpreted to include structures, then that really gets into personal circumstances of Mr. Talibi. If you place a structure on land, then the structure is your personal circumstance. We'll go to page 14. This is the second page of the variance application by Mr. Talibi, not counting the cover sheet, is the second page. And at the top, it again it lists what 5.108 subsection 1B says. If you read the response by Mr. Talibi's attorney in the box there, interestingly, the first sentence reads, begin quote, the property is a rectangular lot that slopes downward from the street to the rear property line, end quote. Just reading that sentence, it looks like Ms. Todd interpreted, in giving her answer, she interpreted property to mean the lot itself, which is the way I think it should be understood. But everything else after that is a personal circumstance. For example, the second and third sentences read, the house, pool, and garage have already been constructed on the lot. A wall with gates has been constructed around the pool area as required for safety, end quote. That's a personal circumstance. The next sentence reads, begin quote, the property is otherwise limited by private deed restrictions, end quote. Well, that's a condition common to the neighborhood. Everybody in the neighborhood, all 47 lots, have the same deed restrictions. The next sentence reads, begin quote, the house is an unusual L shape that created confusion over requirements for the backyard versus side yard, end quote. That's a personal circumstance, but I also submit it's really a bogus statement, and I'll go over that later. And then the rest of the answers there are personal circumstances. Now, to me, when you're talking about peculiar to the property, you're talking about the land itself. And you're talking about a situation where you have a creek branch or unusual topography or something like that, that necessitates a variance. You'll go to page 15. This is from the Mecklenburg County Register of Deeds. This is map book 4 at page 525. I highlighted where 2609, the Talebe residence is, and I marked in 2601 where Beth and I live. And all the lots in the entire subdivision are zoned R3. And you'll see that the houses on Hampton Avenue, other than the corner houses, are all 75 feet wide. And that the depths are very similar. For example, you'll see Talebe's depth in his lot is about 200 feet, which is the same depth that my lot has and most of the other lots. So again, when you're talking about the requirements of the subsection 1B, where it says peculiar to the property such as location, size, or topography. Location and size to the neighborhood are very, very similar to everybody else. If you go to page 16, this is actually something that you can get from the zoning website. You'll see it's the Polaris 3G map for Mecklenburg County. The green box is for Talebe's property. I didn't write that. That's on the original. If you punch in 2609, when you look at the topography. And as you'll see, Talebe's lot, just like my lot and the other lots going up the street, they slope gradually from front to rear. At the front of the Talebe property, it looks like the elevation is about 690. And at the rear of the property, it's about 684. And you'll see that if you look at his lot versus the one just above it, which is where it says Charlotte there, that's where Beth and I live. And you'll see that the topography for his lot and our lot is very similar based upon the topographical map. So it's a gentle slope from front to back. If you go to page 17, this again is one of the exhibits that's attached to the applicant's request for a variance request, variance approval. And the green box on there is the Talebe residence. Again, that was on there if you punch in 2609 when you go to the county or the zoning website. And yes, as they said, the Talebe house is sort of an L-shaped house. You heard me read earlier where their response and justification of the application indicated that it was an unusual L-shaped house that created confusion between the side yard versus the rear yard. That's their term, unusual L-shape. And then you heard Mr. Hoffman testify earlier about the unusual nature of it as well. I would just ask you to look where I wrote in 2601, where Beth and I live. That's a reverse L-shaped house. The next one going up the street, 2545 that I've marked there, the Dunns live there. That's sort of an L-shaped house. If you go across the street from Talebe, the 2606 where I've written it in, that's where the Laymeyers live. And they're sort of an L-shaped house. Again, what they wrote, and this is a direct quote from their application, begin quote, "The house is an unusual L shape that created confusion over requirements for the backyard versus side yard," end quote. Now, if you go to page 18, this again is the Polaris 3G map. It's just a wider view. And the green box and the asterisk show you where the Talebe residence is. I put a red check mark on every house in this wider neighborhood that is either sort of an L-shaped or sort of a reverse L-shaped house. and there are 56 check marks out of approximately 125 houses. So about 40% of the houses in the wider neighborhood are L-shaped. I would just submit to you, there's nothing unusual about an L-shaped house. If you go to page 19.
Mr. Spratt, may I interrupt you for a second?
Sure.
I understand your presentation so far, and I'm looking at, it looks like you've got 87 pages.
I'm going to be able to skip quite a few of them.
I mean, you're not, I understand you're speaking in opposition against this, and I'm not trying to stop your presentation. You're speaking in opposition to this variance, and you're not responsible for making a case. You're not the attorney on this case, and you're not responsible for making this case. And the board understands what our 4 requirements are that we have to meet for hardship. And I appreciate you going through this presentation, and I'm just trying to see if there's a way we can get through this quicker, because we have 6 other speakers after you.
I will speed up as best I can, and I'll skip what I can. Will that work for you?
Yes, sir. I'm just trying to think of everybody's time, so I appreciate it.
I understand. Listen, I realize everybody's busy, and I know that time's valuable. In any event, pages 19, 20, and 21. 19 basically is a diagram in the definition section of code 2.201. It shows the principal structure. It's irregularly shaped, but you'll see that this diagram that's on, again, in code shows the side yard is being consistent, and it shows it being 6 feet wide. If you go to page 20, this is, you heard Mr. Hoffman testify about established rear yard and the confusion that he had between the side yard and the rear yard. Again, this diagram that goes along with the definition of established rear yard, it's easy to understand. The definition is easy to understand. It says the distance between the rear of the principal building or structure and the lot line furthest from the street fronting the lot. If you'll go to page 21, this has the definition for required side yard and established side yard. And the required side yard, what we're talking about here, the first sentence reads, begin quote, the minimum distance required by the ordinance between the side lot line and the side building line extending from the established setback to the established rear yard, end quote. And then the diagram shows that the required side yard goes from the very front of the building to the very rear of the building. So you've got a definition that's easy to understand, and you've got a diagram that helps you understand it. If you go to page 22, this is the cover sheet from Mr. Perry's plans. The green writing is by me. It shows where the established rear yard is, and it shows where the pool house was constructed in the required side yard. We can skip page 23. 24 is just a diagram showing all the pipes that go underneath the ground right behind the pool house. They're very shallow. You'll see 5 of them there. The 2 yellow ones are gas lines. It just, I think, demonstrates the difficulty you would have in doing any plannings there. They've tried to satisfy that with the lattice work, but I don't think that's really sufficient. In any event, going to page 25, subsection B again at the top, I contend, I believe I'm correct, that he fails to meet the requirements of subsection 1B as a matter of law. Go to 1C, which is also shown on the page, and the first sentence reads, begin quote, the hardship did not result from actions taken by the applicant or the property owner, end quote. Basically, Talibi's argument is that it's the fault of the designer, his attorney, his contractor, and the city. He also argues incorrectly, and I'll come to this later, that he complied with the building code, the building permit as it was issued. Page 26, this was before construction started back on July 19, 2018. I reached out to the president of the Homeowners Association and requested assistance. If you go to page 27, this was the letter that I think it's referenced in Mr. Talebi's affidavit. This is the letter that the Myers Park Homeowners Association attorney sent to Mr. Talebi and Ms. Borman on July 20, 2018. And it provided in relevant part, I am writing you on behalf of the Myers Park Homeowners Association. I am writing to request that you familiarize yourself with all applicable zoning and deed restrictions to ensure that the proposed development is in compliance so as to preserve the neighborhood for you and other homeowners. Please be sure to review and comply with all applicable zoning and deed restrictions. If you go to page 29, you heard Mr. Hoffman testify earlier. This is at the bottom of the page. You'll see where Mr. Hoffman wrote a letter to the attorney for the Myers Park Homeowners Association. And he indicated, where I've highlighted, begin quote, Mr. Talebi fully intends on complying with the applicable restrictions and zoning and is building a 2-story house respecting the 40-foot front setback and 10-foot side setbacks. I believe a neighbor may have indicated to you that the house, if you go to the next page, was going to be 3 stories. That is incorrect. The house will be 2 stories, end quote. It's important in keeping in mind the testimony of Mr. Hoffman and also the statements that I'm going to attribute to Mr. Hoffman and the emails involving Mr. Hoffman. Under North Carolina law, the relationship between a client and his attorney is that of principal and agent. There is a presumption in favor of an attorney's authority to speak and act and bind the client he professes to represent. In one case, so holding is Harris v. Johnson at 139 in North Carolina Court of Appeals 827. You go to page 31. This just goes to the part of the code that talks about trying to prevent overcrowding of land. The Talebi house, this is the first page of the permit of the house, 5,855 square feet heated, indicates number of stories 3, bedrooms 5, bathrooms 7. If you go to page, skip over to page 35. This is the building permit, first page of it. And if you go to 37, the building permit for the pool house was issued on August 20, 2018. And down at the bottom under remarks, it says, where I've highlighted, begin quote, construction for this project must comply with all requirements in code section 12.106 of the City of Charlotte zoning ordinance, end quote. Now it says must comply, and under the code's rules of construction, and particularly section 2.101 subsection 4, the word must is mandatory in nature. There is a duty to comply. So there was a duty on Talebi or his representatives, including his contractor, to comply. If you go to page 39, the residents started construction in September 2018. The pool house lagged behind the construction of the rest of the house and the garage. The pool house was framed in approximately February 2019, but then there was not a whole lot of work done on it until late in the summer and early fall. And number 39, exhibit 39, you'll see this is, again, public records, web permit 7.3. This is the building inspector's report of October 9, 2018. That's the day the framing was approved. So that's what the status was at that point. And I would add that that was actually one day after the certificate of occupancy for the house itself was issued. If you go to, you can skip page 40, skip page 41, skip page 42, go to page 43. This is an email from John Beard to Ryan Hoffman with a copy to me. It's dated October 18, 2019. John Beard was the president of the Myers Park Homeowners Association at the time. He wrote in relevant part, Ryan, thank you again for taking my call yesterday. Below are the zonings and covenants that Gilly Spratt believes are at issue. He has outlined the history and references for your benefit. Mr. Spratt would like to keep this as a cordial neighborly meeting with you and Ali Talibi and Sanaz Borman to resolve the below mentioned resolutions. He probably meant violations, but in any event, that's what he wrote. At the bottom of the page is my email to Mr. Beard that was being provided to Mr. Hoffman. If you go to page 44, I highlighted 1, 2, and 3 zoning code violations. Number 1.
I would, again, this is Suzanne Todd. I would object to any alleged violations or concerns that Mr. Spratt has that are not related to the zoning violation and the variance that we're here for today.
And I will try to do so, but in paragraphs 1 and 2, I lump the pool house and the fence together. So in any event, paragraph 1 read, Ali has erected, that's Ali Talibi, has erected a masonry fence surrounding a pool house and swimming pool. Parts of the masonry fence are 3.5 feet from the side property line, as is the pool house, end quote. Paragraph number 2, where I've highlighted it, quote, the zoning code requires a minimum of a 6 feet side setback for the fence as well as the pool house. You go to page 21. Excuse me, 45, my bad, 45. This is an email I sent to Mr. Hoffman on October 21, 2019. I copied Mr. Beard, where I highlighted it, quote, I am concerned that Ali's contractor is continuing to work on the pool house. There have been workers at Ali's contractor hard at work on Friday, Saturday, and today. I was hopeful that after John, talking about John Beard, contacted you last Thursday, Ali would put a hold on the work until we have a meeting, end quote. We had the meeting on October 24, 2019. Mr. Talibi was there, Mr. Hoffman was there, John Beard was there, myself and another neighbor. During that meeting, I addressed them. I again indicated that the pool house was in violation of code, and I again asked that they cease construction on the pool house until the code violations could be resolved. Page 46. This is a photograph I took on October 12, 2019. It was the last one I took in October, so it's the one that I've got that's closest to the meeting we had. But by October 12, 2019, the residence itself had already been completed. You can see the white residence there to the side. And in fact, the Talibis moved in the following day, Sunday, October 13, 2019. But the pool house still had a long way to go. At the time that we had the meeting on October, when the survey was done 3 days later, you did not have the stucco that had been applied to the back of the pool house. You had a coat or two, but you didn't have the final coat. You still had scaffolding up. And then when we met out there on October 24, by then you had the stucco coat on the back of the pool house, but the decking still had not been done. The dirt that you see here in this photograph inside the pool house area, it was still like that when we met on October 24. Page 47. Another email I sent to Mr. Hoffman on October 25, 2019, where I've highlighted the first paragraph, begin quote, my daughter and one of my best friends are realtors, and they believe the structure, talking about the pool house, materially diminishes the value of our property. Common sense suggests they are correct, end quote. Then in the third paragraph, begin quote, I strongly encourage Ali to cease work on the pool house until we reach a resolution, and I'm hopeful that you will convey my request to Ali. I am not copying him with this email since you represent him, end quote. Again, Mr. Hoffman is an agent for Mr. Talibi. Mr. Talibi ignored my requests. Construction continued on the pool house on a regular basis from October 18, when they got the first email notice, until December 2019. And then in January and February 2020, there was intermittent construction going on, which is why they didn't actually apply to have the final inspections until February 24, 2020. And there was a question earlier from Mr. Hoffman about why he didn't reach out to Shad or somebody in zoning if he had any confusion. He talked about the fact there was confusion. Why didn't he reach out after I brought this to his attention on October 18, 2020? Why did they keep building after they had been advised of the problem? I can't answer that. Page 48. This is an email I sent to Mr. Hoffman on January 23, 2020. And I noted there, code section, paragraph 1 of the list of violations, quote, the pool house is built in the required side yard in violation of section 12.106, end quote. Code, paragraph 2, I'll skip that, that's the wall. And I made a settlement proposal that they didn't want to do. If you'll go to page 49, this is the second page of that January 23 email to Mr. Hoffman. And I talked about the fact that John Carmichael, my consulting attorney, had indicated that the pool house was in violation of section 12.106. And then paragraph 6, begin quote, in order to confirm, John, talking about John Carmichael, and I met with the zoning administrator, Shad Spencer, on January 17. Mr. Spencer confirmed that the pool house is in violation of code since it is built in the required side yard, end quote. And I will tell you that when we met with Shad, that it didn't take him more than a few seconds to realize that. I mean, this was, again, the code sections about side versus rear yard, I think, are very clear. Page 50 is an email I sent to Ryan Hoffman on January 30, 2020. And I was in it, I won't read it to save time, but I pointed out that Arc Electric Company had 2 work trucks and several electricians working on the pool house most of that day, that they were working on the pool house. And the prior, I wasn't there at home the day before, but my wife Beth had told me that we working on the pool house the day before as well. Page 51. This is an email from Ryan Hoffman on January 31, 2020. And where I've highlighted, you'll see that he indicated that he still disagreed that Ollie's construction was in any way a violation of zoning. So we're now 3.5 months after we gave the notice. Even a week or more after I've told him about the fact that Shad says it's in violation, and yet Ryan, on behalf of Mr. Talibi, is still saying there's no zoning violation. And based upon his testimony earlier, he apparently wasn't reaching out to Shad to get any clarification from Shad. Page 52, Exhibit 52. In this email, in the first 2 paragraphs, I just requested that they hold off getting a final inspection for the pool house until the, I said city, but I meant county building inspector, until we could get a resolution of the violations. And there in paragraph 2, I reiterated some of my earlier requests that they cease construction, which unfortunately they had failed to do. If you go to page 53, in the middle of the page, Ryan responded by indicating that they would respond to my issues by the middle of next week, but he did not respond to my request from the previous page that he hold off on getting the building inspection, and didn't say anything about the building inspection. I then wrote him back at the top of that page and said, hey, I wish you'd respond to the earlier inquiry, which was a reference to that. So if you go to page 54, I looked online the next day, code enforcement, and you'll see that the same day I'd asked them not to get up final inspections until we could get a resolution, that they entered a request to have final inspections done on February 24. If you go to page 55, when I realized what they'd done, I contacted the building inspector, and you'll see that he wrote on February 24, 2020, begin quote, canceled, hold, placed on permit until zoning issue resolved, end quote. This was for the structure itself, but the same applied to mechanical, electrical, and plumbing. Save time, I'll skip 56 and 57, except to say I was still trying to talk to them about trying to see if we could work out a resolution. 58 is the first page of a letter from an experienced contractor here in town. I realize under paragraph 4 of the hearing procedure protocol that hearsay is not excluded but given limited weight.
Object is hearsay of an expert or potential expert witness.
I'll skip it to save time. I'll skip it. Page 60. Page 60. Okay, here we've got the building permit for pool house again. And on page 60, it says minimum setbacks, front 4 feet, rear 3 feet, left and side 3 feet. If you go to page 62, this is I printed this off online, but it's been there since August 2018, and it has remarks at the end of it so that the contractor can hit go and see what remarks were made. And you'll see where I've highlighted go, Angevin Monique, August 9, 2018, staff reviewer Monique Angevin. She, by the way, is a zoning employee. I confirmed that with Shad last week. If you go to page 63, if they had tapped on that go, which they should have been doing, I mean, the contractor was supposed to be finding out what's going on. This is the date of review by Ms. Angevin on August 9, 2018. This again is online, public record. Zoning R4. Well, it's not zoning R4, it's zoning R3. This should have been a huge red flag to the contractor. It shows front setback 4 feet, rear setback 3 feet. It also says, begin quote, setbacks from property line to water's edge, end quote. If you go to page 64, again, this is another one, just a remark that was put online. This is the same one that I went over earlier that, again, construction must comply with code 12.106. And I emphasize that because that's in the permit itself. There was a duty to comply with that. Page 65. This is the comment by the staff review comment by Ms. Angevin with respect to the garage for the Talibi residence. Again, she indicated R4, another red flag to the contractor if he was paying attention. Page 66. Earlier, I pointed out that an accessory structure can't be built within the setback from the street right-of-way, which is a 30-foot setback. And also, in various places in code definitions, when it's talking about up at the street, such as at Hampton Avenue, it almost always says right-of-way line or the street right-of-way. So in any event, it should have been pretty obvious to the contractor that 4-foot setback was not talking about the setback from the street right-of-way, because if you were talking about that, you could have put an accessory structure 4 feet from the street right-of-way, which would be in violation of 12.106 and in violation of common sense. You go to page 67. You'll remember that Ms. Monique Angevin's report or remark indicated that the pool house, the rear of it, needed to be 3 feet from the water's edge. This is straight from the plans. It shows that the pool house is being built 1 foot from the water's edge. If you go to page 68, this is one of their exhibits attached to the application. It further demonstrates the pool house is just about 1 foot from the water's edge. So Talibi and his representatives failed to comply with section 12.106 despite the mandatory requirement, but they also failed to comply with the erroneously issued building permit. Under the permit, it said 4 feet back from the property line, which has to be the side property line under the circumstances. And they've got an attachment to the pool house that's only 2.9 feet from the side property line, plus the back of the wall of the pool house itself is, according to the most current survey, 3.3 feet from the side property line. So going back to subsection 1C of the standards, Mr. Talibi says he was without fault. I would just point out that it was Mr. Talibi who set the cascades of mistakes in motion and then kept them in motion after the homeowners association and I had notified him that there were violations. None of that deck had been done as of the time we gave him notice and had the meeting. None of the deck had been done at the time of the 3 requests to cease construction that I sent them in October, or that I made during October 2020. The pool house still had a long way to go. I personally watched workers come and go to the pool house and do work on a regular basis from October 18, 2019 until about early December 2000. I should say October 18, 2019 until early December 2019. And then there were finishing touches done during January and February. Okay, if we'll go to page 69, I'm getting close. I really appreciate your patience. This is D of the standards. Quote, the requested variance is consistent with the spirit, purpose, and intent of the zoning ordinance and such that public safety is secured and substantial justice is achieved, end quote. If you go to page 70, this is the purpose and applicability of code and the authority and purpose. In section 1.102, subsection 1, among other things, you're to secure zoning regulations or to secure safety from fire, panic, and other dangers. They're also to prevent the overcrowding of land. Subsection 3, zoning needs to take into account the protection of the values of buildings and land and the use and enjoyment of land on adjacent properties. 71 and 72 just show the fireplace, the chimney of Talibi, 3.5 feet from the property's edge. If you go to page 74, this is Polaris 3G. Remember, the section said that one purpose of zoning is to prevent overcrowding of land. That's a very subjective measure, but I would submit to you this shows: the pool house, the pool, the hot tub, the garage, and the house, but it primarily shows just how close the pool house is to the side property line. And I would submit to you that qualifies as overcrowding of land. Page 75. Under North Carolina law, a property owner is competent to testify as to the value of damages to his property, even if he is not an expert. One case so holding is City of Durham v. Wu, which is at 129 North Carolina Court of Appeals, page 183. I'm certainly not an expert in land values, but I have dealt with appraisers dozens of times I used to handle condemnation cases, and I used to handle tax appeals. I know what hurts and what helps property. In addition, I reached out to my daughter, who's a full-time realtor, and a good friend, Sadler Barnhart, who's a full-time realtor.
I would object as hearsay.
May I respond?
Sure.
Mr. Barnhart's on the line. I didn't list him as a witness, and I should have done so. In any event, if you look at the provision I read earlier, basically it indicates that hearsay is given limited weight.
That's
And I
correct.
get
It's
that.
given limited weight by the board.
Yes. In any event, you'll see what Mr. Barnhart said there in the last sentence, but you don't have to consider that. I would just ask you to rely on the photographs that I provided earlier in your own judgment, which is all you can do. With respect to their appraiser, I would point out that he used two comparables, one of which was he was using condominiums, which I don't think should be used as a comparable for a single-family residence. And for the other one, he really didn't provide you much information about that. If you'll go to page 78, and I'm almost finished, so thank you. When notice was first sent out in May, that hearing didn't take place, but at that time, there were several other neighbors who objected. 78 is an objection from Haley and Scott Laymeyer. They live right across the street from Mr. Talibi and Ms. Borman. 79 is Buck Larimore. He also objected. He lives across the street and down one house. And you heard earlier that Ms. Todd indicated that a neighbor had sent a communication to Mr. Talibi about the importance of zoning. That was actually Mr. Larimore who did that. And I think he even did that before the Homeowners Association sent their letter. Page 80. This is one from another objection from Jay and Catherine Rivers. They live across the street and down two houses. In the last paragraph, they indicated they don't consider it personal law at all. They're just trying to protect the building codes. This is not intended to be personal. It's just a matter of an unfortunate situation and the fact that there's been a violation that the neighbors feel should not be allowed to go forward. 81 is an email from Zell Dunn and John Dunn. They live 2 doors away from the Talibis. It's their objection. 82 is an objection for Pamela May, but she lives a couple of blocks away, but she's going to speak later. You can skip my last 2 exhibits. And then just in closing, I'm going to make a couple of points. I'll be quick. There are 4 people or entities who made mistakes, not counting Mr. Talibi. The designer, Greg Perry, the attorney, Ryan Hoffman, city zoning, and the contractor, Thompson. No one has any recourse against the city of Charlotte. They've got sovereign immunity. And if they've got an insurance that would otherwise waive sovereign immunity, there's North Carolina case law that you can't pursue a municipality for a mistake on a building permit. Perry, Hoffman, and Thompson all owed a duty to Talibi. None of them owed any duty to Beth and me or any other neighbors. So if you grant the variance request, then everyone who owed a duty to Talibi gets a pass. But the people who are supposed to be protected by setback requirements are not protected. That's the exact opposite of the intent of the zoning code. The second point I would make is that Mr. Talibi is seeking equitable relief. In order to get equity, you have to have clean hands. That means it can't be any fault of Mr. Talibi. To me, he's got fault for reasons I've discussed earlier. But even if he has clean hands, even if you determine he has clean hands, you need to weigh the equities. Who should bear the loss here? Should it be the neighbors who raised an issue about the importance of zoning before construction began? Or should it be Mr. Talevy, who promised to abide by zoning but failed to do so? Should the loss be borne by the neighbors whose property has been significantly damaged by the zoning violations? Or should it be Talevy, who kept working on the pool house and the surrounding deck from the time he received notice on October 18, 2019 until February 2020? Should it be the loss be borne by the neighbors who have no recourse other than the Zoning Board of Adjustment? Or should it be borne by Talevy, who, assuming he has clean hands, has recourse against his attorney and perhaps others? I'd like to offer into evidence the exhibits that I've submitted. I also submitted proposed findings of fact and proposed conclusions of law. When I did so, I thought that the law was going to be considered today, so I would need to make a few amendments to the findings of fact and conclusions of law to pull those out. But I'm happy to do so and send them to the city attorney and to Max Oliver. And I really appreciate everybody's time. I know I've gone on a little bit, but I appreciate you listening to me.
All right, thank you, Mr. Spratt. Next person we have to speak is Pamela May. Are you on the phone call?
I am. Hello. Thank you so much. Thank you.
Please state your name and address, and then do you swear to tell the truth? Yeah, do you just swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right. Please state your name and address for the court report.
Pamela May, 2547 Portland Avenue. I am not actually a couple blocks away. I am around the corner. It's a perpendicular street to the house. I did send in an email to Max that is part of your package, and I really appreciate you getting a chance to read that, in which I talked a little bit about the history of Myers Park and what makes Myers Park unique, and that the park-like feel, the green spaces in Myers Park are what make it unique. When our landscape architect came here over 100 years ago and set up those curvy streets, the trees, the setbacks were a big part of it, and zoning is a big part of those setbacks. That's what kind of allows our neighborhood to be our neighborhood. I heard mention of the homeowners' emotion related to this, which is very understandable, and I would bring to your attention that we're also homeowners. We also have emotion about this. I understand that this is their dream home, which engenders compassion and sympathy, and it is in a neighborhood full, like every neighborhood, a neighborhood full of people's dream homes. And I would say that your dream home should not encroach upon your neighbor's dream home. To allow this violation to stand would be an injustice to their immediate neighbors. You can but walk down that street and look at this to understand that, but particularly with light of the restrictions, it'd be an injustice to the surrounding neighborhoods, to the 100-year history of Myers Park, and to all of Charlotteans, the rest of whom are expected and required to follow these restrictions. There is the adage that it's better to ask forgiveness than permission, and I feel like that is what is happening here, and that does engender emotion, because that has come up before in our neighborhoods like others' neighborhoods, and it takes some courage on the part of the zoning board to say, no, this cannot stand, which is going to entail the very thing that your lawyer said it was going to entail, which is that this structure has to go, and you have to build another structure that is going to be in compliance. This letter went out before the first thing had been done on this property, before the first thing had been done on this land, and it's within your hands to make this right, and I urge you to make it right. And I thank you so much for your time.
All right, thank you, Ms. Pay. The next speaker we have is Charlie Welch. Are you on the in the meeting?
Excuse me, Mr. Sanderson, I have a couple of questions for Ms. May.
Yeah.
Okay.
Ms. May, where do you live? What is your
I
address?
live on 2547 Portland Avenue.
And can you see?
So I'm within the notification.
Okay, can you
I'm within
see?
the zoning notification.
Can you see the property, the Talibi property from your house?
I cannot.
Okay, thank you. No further.
Thank you.
Okay, thank you. Mr. Welch, Charlie
Yes.
Welch.
Yes, I'm on.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right, please state your name and address and then provide your comments.
Thank you. And I'll be brief. This is Charlie Welch. I live at 1801 Queens Road, 28207. I am currently serving as the president of the Myers Park Homeowners Association. I've lived in the neighborhood since 1985 and I've been on the board for a number of years. And just have a couple of comments. First, you're all familiar with Myers Park, but to the extent you're not with the Homeowners Association, I think it's important to note we're a volunteer organization, both in membership as well as board members. So we serve voluntarily. I'm serving as president. I'm serving today, volunteering my time here today. And the intent for one of the intents is to preserve the original plan of the neighborhood. And one of the things that we do on a routine basis is work with owners as they're renovating or building new houses. And we understand a lot of the homes in Myers Park are older. We respect people's rights to renovate, to tear down. I was not familiar with this house before the Talibis purchased it, but certainly respect their right to tear down the house and build something new and more modern. I think what we work with homeowners on is to make sure they adhere to deed restrictions and zoning. And so we have found over the years it's better to communicate early and often. So we send letters, as has been pointed out, to make sure homeowners are aware of not just deed restrictions, but zoning requirements. The onus is on the owner to comply with those. We do this probably a couple of times a month. I would say almost all of them are very amicable. Some aren't aware of those. Those that are not fully intend to comply. This is an unusual situation where you have a disagreement. And our general view is, we prefer not to get into pick sides. These are unfortunate situations because Mr. Talibi and Mr. Spratt and others most likely are going to be long-term neighbors. And so because of what's happened, they're going to have to continue to live with each other. And so we try to avoid all that by getting with raising issues up front. I think, one of the things we run into was Ms. Todd, I'm sorry, made a comment about several of the professionals had said there's no other way to build the pool house. And maybe that's correct. I think our point is build what you want, what you can, as long as it's in compliance. If you can't build what's allowed, that doesn't mean to encroach on your neighbor. And in this instance, I think we're talking about 3 feet, which is a significant variance. And with all due respect, to people's judgment about valuation of this Pratt's house, I think a wall of this size will certainly negative impact his value. And I'd ask all those that are considering, think about, would you want to live in a house that had a wall this imposing and this close to your lot line beside you? We did provide a letter, which if you haven't received, Max can give it to you. It's a letter from the Myers Park Homeowners Association where we oppose the variance. We understand perhaps a mistake, maybe several mistakes were made. But at the end of the day, it's a bad precedent to establish, and it is again, as I said, a wide variance from the setback. It's definitely allowed variance. So we would ask that you oppose the variance. And that's all that I had. Thank you very much for allowing me to listen and allowing me to speak.
All right.
I have one question for Mr. Welch. Mr. Welch, what is your profession
I am retired,
and what were you previously?
a banker most of my life.
Do you have experience in real estate appraisal?
I do not have professional experience in real estate appraisal. I've done a fair amount in the real estate area, and certainly, as someone said, kind of know what's good and what's bad for
Okay.
the property.
Do you, but you don't have a real estate license, correct?
I do not have a real estate license.
And you don't have an appraisal license?
I do not have an appraisal license.
Thank you so much.
Mm-hmm.
All right. Thank you, Mr. Welch. Next one up is we have John Carmichael. You on the meeting?
Yeah, I didn't sign up to speak and have no intention of speaking, but thank you.
Okay, so you don't want to speak in opposition or?
No, sir. I'm not involved. No, sir. I have no involvement other than just watching.
Okay. All right.
Thank you.
Thank you.
Thank you, sir.
And then the last person we have signed up for this case is Ben Hallfield. Are you on the meeting? You're muted.
Anderson,
Yes, sir.
this is Gilly Spratt. Ben's computers had crashed and he was trying to participate by telephone. And actually early on, I think maybe before you went on the record, he spoke up and identified himself. So I'm not sure whether his phone service has now died too.
I see he's still on the meeting. He's just muted right now.
Oh, okay. Never mind.
Now he's unmuted. Mr. Hallfield, are you there?
He was participating by telephone, I thought.
Well, Mr. Hallfield, are you on the phone? Max, can you try to give him?
I believe I talked to him earlier, and he's unmuted now. I made him a panelist at the beginning of the case, but I'm not sure if he might be having technical issues.
Okay, Mr. Hallfield, just we need to move forward. So this is if you can let us know something. I believe he was going to speak in opposition from what I see on the list. So we'll acknowledge his opposition to this variance. Does that suffice, Andrea?
Yes, and if you're still in open session and he's able to connect, I would just ask you allow him to try to speak, but before you go into closed session.
All right, I'll ask for him comments before we go into closed session then. All right. Is there any? I think that's everybody that we had signed up to speak. So let's go ahead.
Sorry, Rick. There's a few other people on the line. I'm not sure who they're intending to speak for, but I've unmuted everyone. So if someone else wants to speak up.
Is that you, Mr. Hallfield?
Really appreciate it.
Yes, this is Mr. Hallfield.
Okay, Mr. Hallfield. Do you have some comments you want to make about this case?
Just a few. And
all right,
if
you can just give me a second real quick. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right, then please state your name and address for the court report.
I'm Ben Hallfield, and I live at 2600 Hampton Avenue, which is directly across the street from the Talibis. And very briefly, it is clear when you look at that property that the pool house and the wall loom over the Spratt's property and crowd that property. And I'm struck by the number of warning signals that were given and ignored by the Talibis. And I realize that mistakes were made up and down the line. But if we've got a situation like this where various people were trying to alert them to the problem and those alerts were ignored, I think it's a terrible precedent to say somebody can press ahead with construction, ignore the warnings, ignore the information, come to the zoning board with a completed structure and say, well, a mistake was made at the permitting process or by our professional. We ignored all these warnings that could have been utilized to avoid this problem and grant a variance. I just think this is a terrible precedent if the variance were granted in this circumstance, and I oppose the granting of the variance for that reason.
All right. Thank you, Mr. Hallfield. Max, you said there are other people that may want to speak. Were they not on your list before noon of yesterday?
They were not. There's a couple people that I'm not sure who they are, but they're in the attendees list currently. So I just wanted to make sure that they had the opportunity.
Okay, does anyone else wish to speak for or against this variance? Okay, hearing none, then we'll move on. So I'll give the staff have any questions for the applicant, or staff have any final comments? Lisa or Shad?
No.
Okay.
Mr. Sanderson, this is
Ms. Todd.
Susan Todd.
Yeah, Ms. Todd, then you have the you can have your final statements.
I will make this very brief, and we appreciate your time today. Ms. McCarter, could you pull up my little PowerPoint presentation?
Give me 1 second.
Thank you.
Okay.
And if you could go through the presentation, start scrolling through, and I'll tell you when to stop. Thank you. Stop, please. Back up one more. Ted Thompson is on the line, and I have a couple of questions for Mr. Thompson with regard to this photograph.
Yes.
Mr. Thompson, can you identify this?
Excuse me, Mr. Thompson, please.
Oh.
Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
Please state your name and address before you answer the questions.
Ted Thompson, 4000 Arbor Way, Charlotte, North Carolina, 28211.
Thank you. All right, go ahead, Ms. Todd.
Thank you. Mr. Thompson, can you identify the photograph that's on the screen right now?
Yeah, that is the bathroom to the pool house.
And is that a portion of that pool house?
Yes, it is.
And does that accurately reflect the appearance of the pool house on October 16th, 2019?
Yes, it does.
And what was remaining to be done in that pool house on October 16th, 2019?
The pool decking and finishing the pool bathroom inside the pool house. The stucco veneer was completed. So it was mainly the inside and the decking underneath it.
Okay. Was there veneer on the outside of the pool house facing the Spratt house as well?
Yes, there was.
I've got no further questions for Mr. Thompson.
Okay, do you have a final
The only thing I would,
statement?
Just, I believe we have provided competent evidence to demonstrate prima facie case that we are entitled to the variance. We saw a lot of hearsay evidence. I was not aware of the survey presented by Mr. Spratt today, and I do appreciate him bringing that to our attention. If I may ask to amend our variance and request a 2.9 foot reduction from side yard, that may alleviate any future issues with regards to the boxes, or anything else that might be perceived as being a violation.
So you're requesting a 2.9 foot variance instead of the 2.5 foot variance?
Yes, sir.
Andrea, is that allowable?
There's nothing in our rules of procedure that prohibit that, Mr. Chair.
Mr. Spencer, what's your position?
Would be acceptable to amend the variance request. Now I do question, probably because I know Mr. Spratt indicated that there was a utility box on the back of the pool house, 2.9 feet from the side property line. So I don't know if that variance request would need to be a 3.1 foot variance to allow that utility box. I'm not sure if that's what I'm referring to.
I believe that's correct. I believe the request then would be 3.1 reduction, foot reduction.
Okay, so you're trying to get to the outside of that box, which according to Mr. Spratt's survey said it was 2.9 feet from the property line. So therefore it'd be a 3.1.
That's correct. There's a reason I went to law school instead of becoming a medical.
Ms. Shad, are you okay with that? All right, so now you're requesting a 3.1 foot variance from the 6 foot required side yard to allow a newly constructed accessory structure to remain. That's the current request for 2020-032.
It is. I believe that would alleviate any future concerns with regards to those utility boxes.
Okay. Is there anything else, Ms. Todd?
No, sir, there is not.
Board, is there any other questions that any of the board members may have before we close this hearing?
None for me.
Mrs. Dryden?
I have no questions. Thank you.
Mr. Welch?
I have no questions.
Ms. Allen?
Nothing from me.
All right, then I will go ahead and close this hearing. During our deliberations, there's no comments that are allowed from the applicant or any other parties. So let's go ahead and start our do we want to take a break before we start deliberations? A 10-minute break?
This is them. I don't need one. I'm okay with moving forward, but
Same.
All right, then let's
Just
go ahead.
keep going.
Let's go ahead and start then. Mr. Brown, you want to start?
Sure. The biggest thing that sticks out for me right now is that throughout this process, there were a lot of ways to prevent it to getting to us before it got here. And that's the biggest thing that's troubling for me, is that there were multiple opportunities where it seems like the applicant was aware that this would be a violation of the ZBA code, and they continued to move forward regardless. So that's one of the biggest factors that's weighing on me at this time, but I'm welcome to hear what the rest of the board is thinking as well.
Okay. Mrs. Dryden.
I understand the plaintiff's part. I understand the objections. I'm a little concerned that Mr. Spratt not only is opposed to the variance for the actual structure, but he alluded to often the size of the structure. So too did Mr. Welch mention the size of the structure. I'm a little concerned that we really can't consider that. I want to make sure that we say that to Mr. Spratt and to the opposition, that the size, the height requirement is not what we're discussing here. I understand Mr. Brown's concerns about lots of red flags, and I would encourage Mr. Alidi to seek or Mr. Talibi, I'm sorry, to seek recompense from some of these people when this is all over, because this was flubbed from the beginning, not only from the lawyer, but also from our permitting department. I mean, when the permits were issued, they okayed the permit. And if you're building on and they okay the permit, then you build. And I understand that there were some concerns, but permitting didn't come back and say it was wrong until the complaint was made. So I understand this, and I know it's a tough call. I understand about neighborhoods and how they look and the size. But in this case, I'm inclined to approve the variance.
Okay. Miss Allen.
Hi, it's Emma. I'm actually inclined to decline the variance because it seems like there's lots and lots and lots of communication all along the way that just really seem to be ignored, and that's a huge concern for me. I do think probably recompense or restitution belongs someplace, but I don't believe it belongs at the expense of the neighbors. And I feel for the Talibi family, I really, really do. But in this case, I don't think our job is to provide that recompense, if you will.
Okay. Mr. Welch.
I understand that mistakes were made, and they were made throughout the process. However, as the other board members alluded to, there were times where those mistakes could have been rectified, and at least somewhat addressed. To me, it seemed like the mistakes, the applicant knew the mistakes were there, and just continue to move forward with the erection of this pool house. So I'm inclined to decline this variance request.
Okay. Well, I definitely feel for the Talibis. I understand their situation, but I also, when I asked the question of when they made the case that they went through all the proper steps initially to have an attorney review the regulations, the zoning ordinance, their HOA requirements, and then get with their builder to have the house designed to meet all those requirements, that it would have taken one phone call to the zoning staff to ask the question about if there was a question about the rear yard. Then I would have called the zoning staff to ask that question and get that clarified before providing that information to the designer. I think that would have alleviated all the problems we've had, all the issues that seem to have come up from this. It would have alleviated it coming in front of the board today, at least for this issue. I think that was the beginning of the snowball that grew and grew and grew. So I'll leave my comments at that. Is there a motion, or is there any need to have any further discussion amongst the board?
So just a question, I didn't see it. Is staff recommending or suggesting we decline? What staff's position real quick?
Staff is recommending approval. According to in the findings of fact, that Shad could have approved, the zoning administrator could have approved this if it had been slightly less of an impact. But since it was over that that minimum or maximum amount of staff that the zoning administrator could approve, then it needed to come in front of the board for approval. But they are approving it, saying that the hardship was not a result of actions taken by the applicant, which based upon hearing the evidence today, it may not have been exactly based upon Mr. Talibi's actions, but the people that they employed or they hired to provide them information to make decisions definitely, I think, started the issues that got us to this point.
Agree. Thank you.
Is there any other discussion amongst the board members, or is there a motion?
I make a motion to decline the variance as written.
This is Emma, second.
We have a motion by Mr. Welch, a second by Ms. Allen to deny the variance. We'll take a roll call vote. Mr. Welch.
No.
Sorry. A yes vote is to deny the variance. So Mr.
Yes.
Welch.
Yes.
Ms. Allen.
Yes.
Mrs. Dryden.
I've been persuaded by your arguments, so I will vote yes to deny.
Mr. Brown.
Brown, yes.
Sanderson, yes. So the variance is denied. So we need to go back through the findings of fact and conclusions of law and revise them.
I do not have them, Mr. Chair. I don't know if the board has them, but I need those to be sent to me.
All right, Max, if you.
I sent an email at the beginning of the case. I believe Andrea was copied on it. If not, I apologize, and I will.
I've checked my email. I don't have it right now. If you don't mind resending it, I appreciate it.
You were copied on it, but yeah, go ahead and resend it to her, please.
Yes. It is on its way.
Thank you, Max. Thank you.
So obviously we need to strike number 19.
Rather than
you just want to go through these? How do you want to do it, Andrea? What would be the easiest way, since you haven't received them yet?
you all can go through them, and I will, if I have additional comments to suggest for the board's consideration, you all can come back to me at the end.
Okay.
Rick, look at number 18. Since they requested that we change the variance from the, to 3.1 feet, do we need to change the wording there? Only that the subject exceeds the allowable deviation by 0.5 feet, it would be more than that, wouldn't it now?
Yes, it would be 1.1.
Okay.
I don't even know. I'll leave that. I think that's a question for Andrew. I don't know if we even need to leave 18 in there since we've denied the variance, but I'll leave that. I don't know.
Okay.
But it would be, but since the encroachment is now 3.1 feet, the subject requests the allowable deviation by 1.1 feet.
Right.
And number 19, we should either delete it or take out the word not.
Well, technically, we should probably just take out the word not. The hardship is a result of actions taken by the applicant because they didn't stop construction.
Yes.
Mr. Chair, did you want to include, or members of the board, did you want to include additional language on paragraph 20 concerning the consultation with the attorney, or the nature of that consultation?
I don't know how best to rephrase that. That's a statement that it's important, that needs to be in there. But I don't know how to phrase it, saying that they did not consult with staff to get the correct dimension for the rear yard limits. Is that the way to do it, Andrea?
So perhaps either a new paragraph after 20 or just perhaps a semicolon after the word restrictions, to include the attorney or the applicant relied on. Let me think through that a second. Applicants contacted and relied on an attorney's advice for compliance with the zoning and deed restrictions. Semicolon, however, the interpretation provided by the attorney was not consistent with the city ordinance.
That's good. I like that.
Could you repeat that one more time, what we're saying? Please.
Yes, ma'am.
You're on mute, Andrea.
Can you hear me now?
Yes.
Thank you. The applicants contacted an attorney for advisement of compliance with the zoning and deed restrictions, semicolon, however, comma, the information upon which the applicants relied was inconsistent with the City of Charlotte zoning ordinance. And I changed it a little bit from the beginning, but that's just me rephrasing now.
Okay. Number 22, I don't know if we need to change, how we need to change 22. I mean, there was information presented, but I don't know how much of that was received by by the owners.
So what you do have, and you all can recall your recollection of the evidence, did hear testimony from Mr. Spratt about his communication with certain agents. Again, please rely upon your own recollection of the evidence. You will also need to, board members, you will also need to distinguish between the testimony that Mr. Spratt gave concerning his own personal knowledge versus that of any hearsay or statements by other people. So you can rely on statements that Mr. Spratt made for which he had personal knowledge, but you should not base your opinion on hearsay comments. That you can make that distinction. You could add additional facts based on that. And I know I'm being a little vague, but that's because I can't opine on the evidence for you, but I can draw your attention to.
Could we not just add something that says the encroachment, the applicants were not aware of the encroachment until they were issued notice of violation by the city after construction of the pool house had begun or had started, because there was some building of the structure or before the framing or other, because there were pictures of the framing that were already up when the complaint was made.
Or could we just say after the pool house, semicolon, however, testimony was presented during the hearing that that letters and communications and meetings had taken place with the applicant prior to the notice of violation.
If that's your recollection of the evidence, yes, that would be an appropriate finding. Again, I think the purpose of such a finding would be to show that either the applicant was on notice or should have been on notice of it based upon of the violation and continue to proceed anyway. That is, I would think that is the public policy purpose for such considerations, that when the legislature was thinking through what type of standards were required for a variance, that would be the reason why you would want to include such a finding.
Right. This is where I miss Paul. Having Paul on the board, he could put his legalese to it.
Well, and I'm trying to help without crafting it completely for you, because that's not really my position, but I can tell you that your additional language you propose is consistent with that type of conclusion of law. So it's a marriage between that. So perhaps with paragraph 22, I think Ms. Dryden said the applicants were not aware of the encroachment until they were issued a notice violation by the city after construction of the pool house. Do you want to do another paragraph, or do you want to add additional language to the end of 22, which talks about the additional evidence that you heard?
I think we should add another
paragraph.
Another paragraph.
So a new
23.
So a new 23.
And the 23 would be testimony and evidence was provided during the hearing to indicate that communications, letters, meetings with the applicants occurred prior to construction of the pool house?
Yes, sir.
Or prior to the start of construction of the pool house?
Yes, sir.
Okay. Let's add that as 23.
So that's a new 23, and just push the old 23 down.
Yes. number 25 needs to go away. They're in hardship. I don't think there's no hardship resulting to the peculiarity of the property. The property based upon the site plat, the plat that staff presented is the same dimensions as the rest of them. The information that was presented, other evidential information that was presented shows that the grades are similar to other properties along the street. So I could just say, I guess we could say the hardship does not result from, or there is no hardship resulting from the peculiarity, or just strike it. You think we should just strike that?
So the hardship does not result from the conditions peculiar to the property, as it is similar.
Yes, as it is similar to other properties in the
neighborhood.
In the neighborhood. Number 27. Well, that's their position. I don't know if we can. No reason to change that. That's their position. 28.
So that's an example of conflicting testimony. You have the testimony of the applicant, but you also have the testimony from Mr. Spratt and others concerning whether or not it was the L shape was in fact, that's a question of fact for whether it was in fact unique as opposed to being similar to other properties.
Well, the applicant also stated in their presentation that they had to install a retaining wall to use the property, to maximize the use of the property. So therefore, if they could construct a retaining wall to maximize use of the property, that retaining wall would have supported a pool house in the rear portion of the property, I would think. It seems to me they placed the pool house where they wanted the pool house, and versus where you go in the back of the pool area. But I don't know how it would do with 28.
So I will tell you, Mr. Chair, your findings of fact should be consistent with ultimately your conclusion. So if that does not support your ultimate conclusion, then it probably would not be wise to keep that as part of your findings of fact.
I don't have a problem striking number 28.
It's for the board, but.
Anybody else on the board have a problem with keeping 28 or striking it?
I've got no problem with striking it.
I think we should strike it if we're being consistent, because what they're saying, due to the restrictions by the rear yard, they couldn't build anywhere else. But that's not what we're finding. We're finding that because of the retaining wall, they could build somewhere else.
Right.
So I think we should strike number 28.
All right, and get rid of 28.
And then, of course, as always, on conclusions of law, you would just unnecessary hardships would not result from the strict application. Number 2, the hardship does not result from conditions that are peculiar to the property. Paragraph 3 would be the hardship, strike not in that sentence, following does. And lastly, in paragraph 4, the requested variance is not consistent with the spirit, purpose, and the rest of the sentence.
All right, just make sure you read through it again after other revisions are made, Andrea, and make sure that we've stated what we need, our opinion, what the board thinks, to make sure that if it gets re-looked at, that it's not a wording issue because we didn't word it correctly to justify what the board thinks. You understand what I'm saying?
I will do my best, Mr. Chair.
All right. Is there a motion or any other changes to the findings of fact and conclusions of law?
Before you move forward, and I know you all are in closed session, Mr. Spratt had indicated that he had sent some proposals for your consideration. I don't know if the board received that or not. I don't know if the board wanted to even review them, but I did want to highlight that before you take your vote.
I don't think I received them, but I don't think it's needed I think these findings of fact and conclusions of law will do for the board. I'll leave it up to the other board members.
They were included with the applicant opposition exhibits.
Were they? Okay.
The opposition's exhibits, not the applicant.
Do the other members of the board wish to review those or include those, or just leave ours the way they are?
I'm inclined to leave ours the way they are.
All right.
I'm fine with leaving it.
Is there a motion then?
I make a motion to accept the finding of facts as amended.
Second.
All right, we have a motion by Mrs. Dryden, a second by Mr. Brown to approve the findings of fact and conclusions of law as amended. We'll take a roll call vote. Mrs. Dryden.
Yes.
Mr. Brown.
Brown, yes.
Miss Allen.
Yes.
Mr. Welch.
Yes.
Sanderson, yes. So those are approved. It's 12:15. We have 2 more cases to go. Do we want to take a 10-minute break, or we want to push in through to the next case?
I'd prefer to push in if we can.
Okay.
I second that. I would rather just push it in. Let's move on.
The next case is 2020-037. For a property located at 2320 Arden Street.
The next
Lisa,
case.
okay. I was going to tell you, Lisa, I can't hear you. So if you're talking,
I wasn't talking. I was pulling up my presentation.
Okay.
So the next case is a rear yard variance. The applicant is requesting a 17-foot variance from the required 35-foot rear yard to redevelop a single-family home on the property. And I'll give you a minute to look over your findings.
All right, Lisa, go ahead.
Okay, Exhibit 1 is a vicinity map of the subject property. Exhibit 2 is a zoning map of the property. The property is zoned R5, single family residential. Exhibit 3 is an aerial map of the subject property. The property is in a residential neighborhood. Exhibit 4 is a close-up aerial of the property. Exhibit 5 is the background of the property. The property was created here to our zoning ordinance, and here is an undated plat of the property. The home was built in 1946. Exhibit 6 is the variance request. The applicant demolished the home that was on the property to redevelop, and he wanted to use the already used building footprint. He didn't realize, he got a survey, and it turns out that the existing home encroached into the 35-foot rear yard. And so he's asking for a variance request of 17 feet from the required 35-foot rear yard for an 18-foot rear yard so that he can rebuild in the former footprint of the other home that was demolished. Exhibit number 7 is a consideration of the property depths and the depth of the surrounding homes. The home depth of the proposed home for the property is 31.2 feet, and that's in keeping and consistent with other homes on the street in the area. Another consideration is that deed restrictions require a 25-foot front setback, and so that is less than what is required. So they actually have to push it back a little bit. Exhibit 8 is a photo of the property, and you can see where the old house was demolished. And Exhibit 9 is a photo of the property. And that's my presentation if you have any questions.
Okay, are there any questions for staff? All right. Max, who is representing the applicant?
I have been unable to get a hold of the applicant. He's aware of the meeting, but I don't know if he's having technical issues or not. So he is not in attendance at the moment.
Okay, and he didn't have anybody.
No, he was representing himself.
So, Andrea, do we want to proceed or do we want to continue this case? What's your thoughts?
This is one of the challenges with the virtual format. If we could take about a 2-minute recess just for the exclusive purpose of trying to see if we can get him on the line. It's important to have him on the line.
Okay, can we take a 10-minute break? Take a 10-minute break to 12:30. And Max, if you can try to call him and see if you can get him on the line.
Yep.
All right. Well, let's go ahead and have a 10-minute break, and we'll come back to 12:30. And if he's available to be present, then we'll proceed. I guess if not, then should we continue it then, or give him a chance, or just make the decision?
Let's see where we are. I would like, so for due process, we want to try to see if we can get him on. And then probably move to continue it, Mr. Sanderson.
All right, let's take a 10-minute break, and then we'll see where we get.
Thank you.
Thank you.
Okay. Well, my phone was unplugged, so I unplugged everything trying to get that cord. Let's see. I'll just. He's definitely aware. He submitted everything. He submitted his waiver. I've been in communication with him.
All right, let's see if anybody's back.
It's Emma. I'm back.
All right, hold on. We'll just get everybody back.
And this is Debbie Dryden. I'm back.
Okay.
Pastor Welch, I'm back.
Okay. See if Terry's back.
This is Terry Brown. I'm back.
All right. And let's see. Therese finishing her lunch. Andrea's back.
Yeah.
Max, any luck?
I called him, left him a voicemail, emailed him a couple times. I'm unable to get in contact with him. He was aware. I last had communication with him on the 18th, and he just asked about if there was any opposition to the case. So I don't know if he's having technical issues or, what might be the problem.
Andrea, you're on mute. I can see you talking, but you're on mute.
Oh, no, sorry. Do we have, if we don't have him, is this the first time the case is on? It hasn't been continued before, right?
That's correct.
Okay, well.
And we do have somebody that wants to speak in opposition.
It was initially continued, I believe, in June because of opposition and the way we were handling the meetings at that time.
So this is the first hearing setting, right? Actual, we're here. So,
yes.
It's within the board's purview to continue it. In the applicant's absence, I would say, out of an abundance of caution, we know that the information was communicated to him at some point, or to the applicant at some point. I would hate for the board to make an adverse decision or any decision, quite frankly, without the applicant present for at least one time. So if we're in this situation next month, it'll be a different thing, but I think it would probably be prudent for the board to at least consider continuing the case. But it's completely up to you.
Is there any discussion from the board, or is there a motion to continue the case, or do you want to proceed with it?
I think we should continue it only because it hasn't been continued before, and there is somebody speaking in opposition. So we should give the person asking for the variance at least one opportunity to speak to us. So I make a motion that we put this on next month's agenda.
I second that. I agree.
All right, we have a motion by Mrs. Dryden and a second by Mr. Brown to continue this case to September to allow the applicant to be present. We'll take a roll call vote. Mrs. Dryden?
Yes. Yes.
Mr. Brown?
Brown, yes.
Miss Allen?
Yes.
Mr. Welch?
Yes.
Sanderson, yes. So that'll be case 2020-037 will be continued until our September meeting. Our next case is 2020 57 for property located at 4317 Pebblebrook Drive.
All right, the next case is a residential rear yard variance. The property owner is requesting a variance to allow for a 16-foot reduction to the required 40-foot rear yard. And I'll give you a minute to look at your findings.
Max will need to send those out because I don't have them.
They're on the way.
Thanks, Max. Just got them. Okay, Lisa.
Slide number 1 is a vicinity map of the subject property. Slide number 2 is a zoning map of the property. The property is zoned R4 single family, and it's surrounded by other R4 single family. Exhibit 3 is an aerial map of the property. The property is in a residential neighborhood. Exhibit 4 is a close-up aerial map of the property. Exhibit 5 is the background of the property. The property was subdivided in 1963. You can see the plat on the left-hand side of the screen. The home on the property was built in 1968. The property currently has an established rear yard of 35.3 feet, which is a 5-foot encroachment into the required 40-foot rear yard. The applicant would like to extend the existing encroachment and is asking for a variance 16 feet into the 40-foot rear yard to allow a 24-foot rear yard for the property. And you can see on the screen on the left side the plans proposed. To the right side of the property is a proposed heated portion of the addition that will come 24.1 feet from the property line. And then over to the left side, that proposed addition portion is a screen porch, and that is 24.8 feet from the property line. The application also includes a request for a variance for the covered porch portion to encroach more than 25% of the depth into the rear yard. But if the variance is granted, then the proposed screen porch will not encroach further than the proposed heated addition. So they will not need that 25% encroachment provision. So it will be allowed if granted. Staff does not support the proposed request. Staff would support a modification that doesn't extend the existing encroachment. And the modification would be the support of a 35-foot rear yard and a variance of 5 feet, 40-foot required rear yard. So since there's 2 different scenarios, I've included the numbers on the screen on the left-hand side. The blue line is the established rear yard of 35 feet. To the right addition on the heated space, if we with a 35-foot rear yard that didn't extend the existing nonconformity, there would be left 10.9 feet that they would not be able to build of the heated portion of the structure. Over on the left-hand side of the structure for the proposed screen porch, they would be allowed to build all but 1.45 feet of what they were proposing. And so you can see on the bottom right of the screen in the yellow areas, all the building area that this would allow. And they could also build a second story, and there's more yard area to the left that they could build on. On the application, there was also a portion that asked for a variance of 90 degrees. A 90 degree is not a zoning ordinance requirement. So the way and I think that it had to do with the way we measure the rear yard. The rear yard definition specifies that it's the minimum distance between the rear of a principal building or structure and the lot line farthest from the street, measured parallel to the rear lot line. So that's how we've measured the rear yards. Exhibit number 9 is considerations that other homes in the area have irregular shapes and similar depths. So you can see I've labeled some of the other lots. There's one that ranges from 0 to 140 foot depth, 100 to 120 foot depth, 75 to 115 foot depth. So the lot is similar to the other lots. Exhibit 10 is a photo of the property. And that's all I had. If you have any questions.
So did staff propose the modifications to the applicant?
Yes, staff from the beginning told the applicant that they would be in support of the keeping the established setback. The applicant did not agree to that.
Okay. All right. Are there any questions for staff from the board? All right. Mr. Sturdivant, are you in the meeting?
Yes, sir.
All right. Would you let me do this first. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right. Thank you. Then please state your name and address for the court reporter, and then you can start your.
My name is Carl Sturdivant, 4317 Pebblebrook Drive, Charlotte, North Carolina, 28208.
Okay. Thank you. Go ahead and you can present any information or make any comments you want, any questions you want.
I would first of all like to comment on Ms. McCarter's comment that my lot is similar to the others in the area, which is not. If you notice that my lot is the most shadowest, the rear yard is the most shadowest it is in the neighborhood. My lot from the front to rear is a 75 foot from the road to the rear of the property, which is different from the same adjacent property. Her house is facing Allegheny, and that 75 feet on her side is a little bit different. I have one of the smallest lots it is in the neighborhood. And I'll also like to point out that that giving the angular shape of the rear lot, that similar variances has been granted in the on an angular rear lot, and mine is no doubt, considering the fact that it's approximately 100, let's say 22, almost about 47 feet difference from the rear yard line to the from one side of the property to the other, left to right to the other. Also, there's an issue if you look at the original lot, that would be exhibit when the house was placed on the lot, it appears that even then, prior to any variance approval, I would be on page 7, and the old house, and it appears that house was measured, that my house was measured, well, from a 90-degree angle off of the house to the rear property line. And it being measured 90 degrees off of the house to the rear property line would basically decrease the variance from 16 feet to 11 feet. And I'm thinking it was and 1 feet prospectively on the left-hand side where the covered porch is at. I would also like to point out that in support of that the original house of page 7, where the property line is merged straight, that there's another case here in Arden. I'm thinking her name is Arden Matthews. Well, that was the surveyor. But this case, they actually, this board, this administration, basically approved another house in that was variance, but they approved the survey sheet that was measured also 90 degrees off the house instead of the property line. I'm trying to determine, figure out how is it possible that you can approve one in the same district and deny me, and you're basically under the same zoning district. I would like to add on to the rear of my house to add a laundry room and an existing utility room as well. And I would like to point out also that going out further to the side yard with a uniform roof would encroach even further into that left side rear yard. So.
Okay, is there anything else?
Not for now.
Okay. Lisa, I have a question for you.
Yes.
Shad, in your findings of fact number 7, you say the established rear yard on the property is approximately 35 feet. Is that on your exhibit number 7 that's currently shown, the 35 feet you show as exact established rear yard is 35 feet, and it goes to the corner of the existing structure, is that correct?
Yes. Mm-hmm. Measured parallel to the rear line.
Right. But then in the next, in item 9 in your findings of fact, you say you have a 40-foot required rear yard. Why is it increased to 40? Is that because they're doing an addition?
So that's the required rear yard, and one is the established rear yard. The established rear yard is 35 feet, but the required rear yard for the zoning district is 40. So they're encroaching 5 feet, but it's non-conforming because they were there prior to the ordinance requirements.
Okay, so I see what you're saying. Okay. But the building envelope, I guess that now on government exhibit number 7, on the photo in the upper left corner, the shows a dashed roughly triangular line. That is the allowed building envelope with the setbacks?
Correct, yes. The required ones.
And based on that triangular area, there's really no place that Mr. Sturdivant could expand his structure without going up. Because any of the additions are going to be so small and oddly angled. It's kind of putting that property in that structure and that property in a bind. Is that correct?
So that's up to you to decide, but staff typically doesn't support an extension of the encroachment. The existing encroachment into that 40 is 5 feet. So we would support keeping that and not extending it further. And that would allow all that's shown in yellow on the right side of the screen that the applicant is proposing. But yes, going up is another option.
I understand the yellow, but in realistic terms, nobody's going to want to construct a triangular addition to the back of a house if it doesn't really have a whole bunch of space to do what they want to do. So from a realistic standpoint, that's not probably possible, but that's just my opinion. But in order to get to he said he would need a 16-foot. He would need a 15.9 or 16-foot encroachment to get to the point that he proposes to add on in the back.
Correct.
And the screen porch.
Yes.
Okay.
And I will say staff does recognize that there is some hardship based on the size of the lot. That's why we had proposed and support a 5-foot variance, which would then take the property to the established rear yard and be 35 feet.
And that would just get the house
allow for like kind of government exhibit number 7, the lower right hand illustration, that everything in yellow would be allowed to be added.
Right. But really, that's getting the house in conformity as well. Right? You're on mute.
I'm sorry, did you ask the question?
Yes, I said that's really that also gets the house into conformity.
Yeah. We're having to go back and forth of turning off our computers because they echo in here. So can you please repeat your question?
If we grant the 5-foot encroachment into the 40 to get 35-foot established rear yard as the setback, that gets the existing house into a conforming status from a non-conforming status.
Correct.
Okay. Mr. Sturdivant, is there any way would you consider going up with your addition, or is there another way that you could configure your addition to get outside the setback?
Sir, when you say going up, are you applying 2-story?
Yes, sir. I'm just asking the question.
Well, I know I'm not. It's the request is not supposed to be personal, but I just turned 60 this year and worked on elevators since 1977. And I don't really want to go into a 2-story house. One of the reasons that I wanted to expand and was basically because of not having to go out and trying to buy a new house and trying to buy a house with 1 story on a lot here in Charlotte with the price here in Charlotte. But that going up to me would be it would be a little bit strenuous because we would have to cut into the regular floor and get a substantial foundation that could handle the additional weight of 2 stories. So I to answer your question, I don't think that it would be feasible to do.
Okay, I just wanted to exhaust the option, so that's why I asked the question. All right, is there any questions from the board? Mr. Brown, Mrs. Dryden, Mr. Welch, Miss Allen?
I don't have any questions at this time.
I have one. I mean, given that this yard, I mean, the 5 feet, yes, he's not in compliance, but that was before there was even any compliance to be had. So with that 5 feet a given, how much then more is he asking?
11.
11. Okay, thank you.
He gets if he needs the 11 10 he needs 15.9 feet to get to the corner of his proposed addition to be within the setback. So it would be reducing the 40-foot setback by 16 feet.
Right, minus the 5 would be, I see where you got the 11. Okay, thank you.
Yes. All right. Any more comments from, Max, is anybody in opposition? I didn't see anybody on the list.
We had one person signed up, and I believe they're here, Ella McManus, and I don't believe she stated to me one way or another if she was for or against.
It says for information only is on the spreadsheet.
Yes. Let me see if I can get her pulled up. She should be unmuted now.
Ms. McManus?
Yes.
Yes. Do you want to make any comments for or against this variance?
No, I logged in for my son. He's here, and as far as I'm aware, he has no opposition to it. Do you, Joe? He said no.
Okay. All right. Well, thank you. I think is that the only?
And I spoke with a woman named Brenda yesterday. I did not catch her name, but she stated that she was in favor of the variance.
Okay. All right. Well, Lisa and Shad, is there any other comments you want to make for a final thoughts?
No.
Mr. Sturtevant, is there anything else you want to, you get the last word. Is there anything else you want us to know before we start deliberating?
Well, like I said, on page 12 of my application, I really would like you to consider where this was. Let me get back to my. I think this was 3939 Hoff Road. And we're talking in response to the to where she got a 19.5 foot rear yard reduction, but they also used their line coming off of her house. They run the surveyor measured the property as approved by the zoning board 90 degrees off the house instead of the property line. If my if my yard was done like that, you would have 40 feet. I pull a string line from stake to stake on the rear property, and it's right around 40 feet if it was done like that. And I just wanted to make that comment that this practice has been in place sporadically throughout Charlotte, the zoning area of Charlotte, the zoning district of Charlotte, and I'd just like you to take that into consideration in granting or denying my variance request for this property.
Okay, thank you.
Can I respond to that?
Yes, I haven't closed the hearing yet.
Okay, so we looked up the old presentation for that, and actually, we did measure it, the rear yard, just like we're measuring it now.
But I don't have any, there's no evidence that it's measured that way.
This was in the old
I asked for everything that you had on this property, and that's what you sent me. So I reject that particular statement on that.
All right, sorry, I had to step away just for a second. All right, thank you, Lisa. Is there anything else? Any other comments?
I don't have any.
All right, well, thank you. Then let's go ahead and close the hearing. We'll start off with Mr. Welch. What are your thoughts?
Going on, just looking over, well, with the new information that is sent over about the previous home that they measured, like they measured all the same. So to me, it's nothing different from what they're doing throughout. So again, I just would be interested to hear what everybody else thinks about it. But to me, it's like we're not doing anything different from this house.
Okay, so
I'm just like to hear what everyone else is thinking.
All right. Miss Allen.
It doesn't seem like an unreasonable request to me, so I would lean in favor of approval of the variance.
Okay, Mrs. Dryden.
I don't really see any issues with affording him this variance. You're still going to have a goodly portion of rear yard. And I understand, I mean, I know technically we're not supposed to take into consideration his age, but skating will just arbitrarily will just build up. But for, a lot of people, that's not a viable option. So based on looking at the lot size and the odd shape of the lot, I would be inclined to vote for this variance.
Okay. Mr. Brown.
Yep, no, I agree with what's been said for the most part. I think that there is something peculiar about the lot shape, and it's kind of evident that it would be difficult to do vertically. So right now I'm in favor of granting variance as well.
I agree. I think that the peculiarity of the lot is mainly the peculiarity, the small size of the building envelope that's on the lot based upon the setbacks, the required setbacks. And my thoughts would be in order to add a second floor, it would essentially be a tear down and have to redo because you'd have to add substantial foundations in order to substantial wall improvements on the first floor to build a second floor on top of it. And I don't know the applicant's requirements or conditions, but, you know, he said he's, you know, being older, 60, I'm going up and down stairs would maybe not the best thing. It isn't for me, and I'm not 60, so I mean, I understand that. So I understand. I think that I agree with everybody's thoughts. Any other comments or questions, or is there a motion?
This is Kerry. I move to approve this variance.
Okay.
This is Emma, second.
All right, we have a motion by Mr. Brown and a second by Ms. Allen to approve the variance. We'll take a roll call vote. Mr. Brown?
Brown, yes.
Ms. Allen?
Yes.
Mr. Welch?
Follow with everyone else, yes.
Mrs. Dryden? Ms. Dryden, you're muted.
Now, yes.
Yes.
Sorry.
All right. And
Went too many buttons.
Sanderson, yes, that's approved. So let's look at the findings of fact and conclusions of law. I think we need to change number 10.
Do we need to change number 10?
Yes.
So could we just take out no, there is evidence of practical difficulty or unnecessary hardship?
Yes, Ms. Dryden, you're correct. There is evidence of practical difficulty and unnecessary hardship, comma, including, and I would suggest including some of the you all discussed. You did highlight the fact that the age specifically can't be used, and you're correct about that. However, I think just the building envelope, your discussion about that, as well as any evidence that you heard concerning his unique hardships outside of age, of course, but I think you all had some robust discussion about other aspects that could be considered hardships as well.
So I think it should probably read, there is evidence of practical difficulty or including a small building envelope within the required building or property setbacks, as well as the inability to expand vertically due to the extensive construction that would be required. Is that allowable?
Yes.
So it would be, there is evidence of practical difficulty or hardship, to comma or semicolon, than that. Okay. I think we need to strike number 14.
I agree.
Number 15 needs to be modified as well. The hardship does not result from actions taken by the applicant.
Right. And then we need to strike number 16.
Correct. What about number 17? Do we need any of that?
Doesn't that go away with the approval of the variance?
Because we approve the variance, it doesn't matter.
You all are correct. 17 is not necessary.
And then obviously the next sentence about staff recommends the following modification goes away. And the whole part about the findings related to the modification.
Right.
So just need to be conclusions of law for the variance. And that would be, and those would be the same then. The four conclusions of law would be correct. We just take out the word modified variance because we approve the requested variance. Is that correct, Andrea?
Yes, sir, it is.
Okay. A motion. If the board members are talking, they're all muted. I can't hear them.
Okay, I make a motion to accept the amended finding of facts and conclusions.
Second.
Okay, we have a motion by Mrs. Dryden, a second by Mr. Brown to approve the findings of fact and conclusions of law as amended. Take a roll call vote. Mrs. Dryden?
Yes.
Mr. Brown?
Yes.
Mr. Welch? Mr. Welch, you're muted.
Yes. Yes.
Ms. Allen?
Yes.
Anderson, yes. Those were approved. And I just noticed that Mr. Patterson has joined the call for case number 2020-037. So, Mr. Patterson, are you able to hear and participate?
I'm sorry, I will unmute him. I believe Miss Anderson is still on the call as well. So if we can proceed with that case, I believe we still have that ability.
Is there anything special we need to do since we've already voted to continue it? Can we do it today or not?
Just so the record's clear, if you can get consensus from the board, I don't think a formal vote is required, but I think you can get consensus from your board by just thumbs up from the board. I think we can move forward.
Is the board okay with moving forward in case 2020-037?
I'm in agreement with moving forward. Deborah Dryden.
All right.
Jerry Brown, that's fine.
Okay, let's go ahead and finish this up then. It's 2020-037. Mr. Patterson, if you can hear us and participate, then that will go ahead and do your case. Can you hear us, Mr. Patterson?
He is unmuted and I've made him a panelist.
See that?
I just messaged him.
Mr. Patterson, can you hear us?
Come on, Patterson.
He says he is here. He just messaged me.
He's on his cell phone, it looks like.
Let's see.
Okay, Max, while you see if you can get Mr. Patterson, let's go ahead. We need to approve the findings and fact and conclusions of law from case 2020-2021 from last month.
Oh, yeah.
I think those were sent out earlier.
Yes.
Move to approve those findings of fact and conclusions of law.
Okay.
Hello, can you hear me?
Yes, Mr. Patterson.
I cannot hear anyone. I'm not sure why.
Hold on, Mr. Patterson. Let's take care. Max, work with Mr. Patterson for a minute. Let's try to get this other thing taken care of. We have a motion by Mr. Brown to approve the findings and fact and conclusions of law.
I'll second.
All right.
Hello?
Let's do it. Yes, just a minute, Mr. Patterson.
Okay, there we go. I hear you now.
All right, just give me a minute, Mr. Patterson. I'll
Sure.
come right back.
Yes, sir. Thank you.
So we have a motion by Mr. Brown and a second by Mr. Welch to approve the findings of fact and conclusions of law for case 2020-021. Take a roll call vote. Mr. Brown?
Brown, yes.
Mr. Welch?
Welch, yes.
I was not here at the last meeting. Am I in a position to make that vote?
No, that's okay. As long as we have 4, we're good. Mrs. Dryden?
Yes.
Sanderson, yes, those were approved. And then let's do the last one real quick, and then we'll get to Mr. Patterson. Case 2020-026, the findings of fact and conclusions of law were sent out. I didn't see any changes to them.
Move to approve those conclusions of law and findings of fact as well.
All right, thank you, Mr. Brown.
Dryden, I'll second.
All right, we have a motion by Mr. Brown, a second by Mrs. Dryden to approve the findings of fact and conclusions of law for case 2020-026. Mr. Brown?
Brown, yes.
Mrs. Dryden?
Dryden, yes.
Mr. Welch?
Welch, yes.
Sanderson, yes. Those are approved. Okay, Mr. Patterson, can you still hear us?
Sure.
Okay, good. Before we get started on your case, let me do this. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes, sir.
All right, thank you. Lisa, let's go ahead and do your little do the presentation for this case.
This presentation. So
37, go.
I'll just do it real quick. So this is a 17-foot variance from the required 35-foot rear yard to redevelop a single-family home on the property.
That's correct.
Exhibit 1 is the vicinity map of the subject property. Exhibit 2 is the zoning map of the property. The property is zoned R5 single family, and it's surrounded by other R5 single family zoned properties. Exhibit 3 is an aerial map of the property. Exhibit 4 is an aerial close-up map of the property. The property, the home on the property was constructed prior to any zoning ordinance regulations in 1946. And this is an undated plat to the left of the screen showing the subdivision of the property. The applicant demolished a home on the property and wanted to rebuild within the former building lines. And property survey revealed that the former home encroached into the 35-foot rear yard setback. So the applicant is asking for a 17-foot variance from the required 35-foot rear yard for an 18-foot rear yard so he can use the footprint of the former home on the property. Exhibit 7 are considerations. The home depth is consistent in character with the surrounding area. So the home depth proposed is 31.2 feet. And surrounding home depths are maybe a little less and maybe a little more, but around that same amount. And then over to the left, you can see a survey. The rear yard is shown in a green dashed line, and the front setback is shown in a green dashed line. And so the green dashed line in the front is showing the required zoning setback. There's actually deed restrictions that require even more of a setback on this property. So that pushes what they can build further back onto the property. But the property depth in the allowed buildable area is about 18.9 feet to 39.43 feet. So staff does support the proposed variance request. Exhibit 8 is a photo of the subject property. And Exhibit 9 is another photo of the property from the street. And that's my presentation if you have any questions.
Okay. Any questions for staff? All right, Mr. Patterson, you have anything you want to talk about or present?
Sure. When I bought the house, I had every intention of remodeling the house, renovating it, and adding on to the right side within the in between the two setbacks, the front and the rear setback. And as we got into the construction, we realized how bad of a shape the home was, just rotting wood and just falling apart. And on the right side of the home, it was the siding was literally touching the ground because it was such the foundation was there was just no brick foundation left. There was maybe it was negligible amount. So we decided with all of that information, we decided that we would remove all the framing and try to build up the foundation. And then because we needed that on the right found, and then with the framing, was in such horrible shape anyway, we decided, well, we'll just rebuild the framing. So when I called for the permitting, I called the permitting department and I asked them, I said, would this be considered new construction if I left all of the foundation, the footprint? Would that be a problem with, would that be considered new construction, or that's still considered a renovation? And they said it would be considered a renovation. I said, okay, so if the footprint stays the same, and it's a renovation, then I won't be encroaching into any zoning issues. Well, so with that information, we removed all the framing, and then found out from zoning that was not that we had to go through this process then, because even though the footprint is still there, all of the brick foundation is still there in the original footprint. Because the framing was removed, it is now considered new construction, and so now that's why the variance is now needed. So I hope that makes sense.
So you're going to build a new structure on the same footprint?
Exactly.
So there's no expansion. Okay.
Well, there is expansion, but the expansion is on the right side, and that's in between the front and rear setback. So there's no expansion
outside of the setbacks.
That's correct. That's correct. Yes.
Okay. Any questions for Mr. Patterson? Okay. Ms. Anderson, thank you for waiting patiently for so long. Do you have comments that you want to make?
Well, yes.
Okay, before you start, let me do this real quick. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right, then please state your name and address, and then let us know what your comments are.
I am Elizabeth Anderson, 1229 Berry Ridge Road, 28270.
Thank you. Now, please let us know what your thoughts are on this issue.
Well, this 2320 Arden is a very small lot, and it's on a hill, and water runs down on my property and it pours down. So back early in the 50s, we put a concrete wall around, very expensive at that time. And the back wall has fallen now, but we tried to keep the materials to pack against that hill. But we still have water problems, and we put cement patios and everything to sort of hold the soil in. But now this new plan that for 2320 seems to be a larger building. It'd be elevated, and the back of the building just don't add up to what they're saying the space will be back there. It's where it is now. It's already at the look like the, you know, it just doesn't look like it's that much space back there from where it was built. The last building was there. So then on one side, where the hill is on my property, where the water runs down, it's not 10 feet in some of those places. And so it seems as if a larger building on that, with all these gables and all, with water running down and it floods on the other piece of property too. There's two lots there, lot 1 and lot 2, facing Vanderbilt Road, and the backs and sides encompass 2320 Arden Street. So I was thinking maybe if he could build on the same base that is there, maybe we could continue to work with the flooded part. But if it's going to cover the entire little lot, and it might just be left disturbing the land, that we'll have a bigger problem with the flow of the water, because when it rains, it still floods. It just runs down Arden, and then it just.
Mrs. Anderson, what's the address of your property? I'm looking at an aerial map. I'm trying to make sure I know exactly where you live.
Now you want the address of the
house the property you're talking about flooding from getting the water from this property. I'm just trying to figure out. I'm trying to get in my head where your house is.
Now you want what, the address?
Yes, ma'am. For the houses you said the water comes down the hill and gets in your backyard.
Okay, there are 2 houses, and it's lot 1 and lot 2 on Vanderbilt Road. The addresses are 2323 Vanderbilt Road and 2317 Vanderbilt Road. Now 2317 Vanderbilt Road and 2320 Arden are pretty much, well, back to back, except it ends up with a part of that water running down where he doesn't have much space there. It's not 10 feet on that side. And the other part is 2323 Vanderbilt Road, where that side is across the back of 2323 Vanderbilt Road.
Okay, I understand. I see what you're saying now. Okay. All right. Thank you. Is there any other comments or you want to make?
Well, I do oppose to
But if they build on the same footprint, and I don't know, I'm going to ask Mr. Patterson here in a second another question about the size of the building. But he says he's going to build on the existing footprint and a small expansion. So I'm going to try to find out what that is. But that'll be my next question. But
well, it seems as if it says on this blueprint it was already a setback, and then he's asking for another setback. Well, those dimensions just don't add up to me. A building, the building is really a different. It's really a different blueprint. Those dimensions. It's a bigger house on that small lot.
But the way I understand it, Mrs. Anderson, is that the house was built in approximately 1946, before the zoning requirements were in place. And then the zoning requirements came in place, and it was zoned R5, which that doesn't mean anything right now to you and me, but that's just the district. And it's supposed to have a 35-foot rear yard setback. And when you overlay that on top of the property where the existing house was, or the foundation still is, that goes into that 35 feet by about 17 feet. So it's this encroachment this variance that he's requesting is to get the existing footprint of the house to be in line, in order with what that 35 foot is. So what that setback is, in order to get into conformity, so he conforms with what the ordinance says, he needs that 17 feet. So he's not asking for an expansion of the building footprint. He's just asking for this board to approve making the rear setback smaller to just get to the limits of the existing foundation.
So that includes the easement.
I don't know what easement you were talking about.
Okay, at the back, he has a 5-foot utility easement.
That would still
that's 5 from the 17.
No, ma'am, that's just on top of the 17. That's just part of the 7. That's just part of that remaining easement. That's always there. It doesn't have anything to do with the easement that the encroachment that we're talking about today.
Yeah, they're talking about today, again, asking for 17 the 17 feet. Well, are they putting a building back there all the way back to the 17?
That's where the old house that was built in 1946 went to. That was where it was. That was the back corners. The back corner of that house that was torn down. The pad is still there, but the foundation is still there. But that corner was the 17 feet from the back property line. But it should have been 30, based upon zoning ordinance today, it should have been 35 feet. So what he's requesting is just to get that area between the existing foundation where it was built in 1946 to the zoning ordinance limit of 35 feet, get that approved so he can put a new house back on that same slab, for lack of a better term.
Now what about on the side where near the back on the side it's 6.7 feet.
Nothing's going to change on that side.
The building or anything will not be on that side. It will be on.
It'll start at that same 6.7 feet from that side. It'll be where the outside of the new building will be. There'll be it looks like there'll be a small expansion, small add-on on the other side of the property, but not on the 6.7 feet side.
What do you mean add-on?
There'll be a little room, it looks like, a room added on the other side of the house. When they build a new house, it looks like there'll be another room, a small room on the side opposite over the 6.7 feet. So it'd be uphill from where you're talking about.
Okay, but the room will be on the other side.
Yes, ma'am.
Not on the 6.7 feet side.
That's correct.
Because there's not enough room over there, I'm sure.
Yes, ma'am.
Now the backyard it's going to end up being
exactly the same as it was. Is what he's saying on his plan. It shows it'd be exactly the same.
And it is exactly the same. I'm just worried about a bigger house, elevation, and gables, and more water running down.
Well, all I can say is this plan shows that the back of the house will be the same location as the old house, and the backyard will be the same depth and as the existing backyard. That's all I can say based upon the plan that I'm looking at right now. That's been presented to us for us to make this decision. Now it'll be up to obviously him to do it the way it's approved by this board and by the building permit people to make sure that it's done within those requirements. But as of right now, as of today, that's the plan that is shown in front of me, shows that the backyard will be the same as it has been since 1946, and the back of the house will be in the same location as it was built in 1946. Just be a new house.
Okay, so same as it is now, the backyard of both of those backs are not very big, so I was concerned with that. Okay, now if this is going to be built, on the same land, is no extension of anything on my part. And you said it would be an extension of the building on another side away from my property.
That's correct.
Okay, with that said, and all of that being true, then it's okay. It's okay with me.
Okay.
But if he's doing anything differently, you know, I don't want any trouble.
I understand.
It's a waste of a lot of time. And we wasted money on that property years ago, back in the 50s, putting concrete walls to hold the water back. One concrete wall is falling down because it was, you know, weathering, water running down on it. So now we got that pushed up against that hill so that it won't wash down any further. Then the other wall is old, it's almost 70 years old. So
I understand, but yeah, so like I said, the way the plan looks is that's as I explained it.
well, but he can hear what I'm saying, right?
Yes, ma'am. He's on the phone. So is the zoning administrator for the city of Charlotte.
Okay.
And none of them have said that I've said anything incorrect.
Pardon me?
None of them have said neither one of them has said that I've said anything wrong. So I've said they agree with what I've told you is what's going to happen.
Okay.
So you have any other comments then?
Well, not from what I've just heard that it's going to be built on the same, except that further over to the right, that's not near my property. So, do I need anything in writing on that?
I don't think so. But that's really up for you to make that decision. I can't give you anything in writing. I'm just telling you what I'm looking at, and that's the information presented to the board.
Nor can you make representations on behalf of the board in that. I mean, from a legal capacity, I think that question really does go to the core of a legal representation, which this board is not in the position to make to this witness.
All right.
So what you just said, I would need legal help.
Ma'am, what I was saying was that I think you're asking Mr. Sanderson to whether or not you need what's happened here to be somehow represented in writing. And what Mr. Sanderson has done up until this point is provide an explanation of the process and what is intended to move forward in this. Now, I will tell you at the conclusion of today's hearing, there will be a written decision that will memorialize the actions that they've taken, but beyond the written decision, that is the only thing that this board will be putting in writing for you or anyone else in the public to receive. So if you would like something beyond that, it would not come from this board. The board will only be issuing a decision today.
And how do I get to that? It's for the public.
So you can once this decision is rendered, the board will issue a written decision, and you can obtain a copy of that from the zoning staff. So Mr. Spencer or Ms. Carter will be able to provide, or Mr. Oliver, either one of those individuals will be able to provide you a copy of this board's written decision after it's finalized.
Okay, but I can't pull it up anywhere.
Ultimately, I believe, again, I will yield to staff. I don't believe our decisions the variance decisions are placed online at a later time. But again, once I would say give it a few weeks to get a copy of it from the board or from staff, but certainly you can contact staff and ask them when the decision will be ready.
Okay, thanks.
Yes, ma'am. Thank you.
Are there any more comments, Mrs. Anderson?
No.
All right. Well, thank you for your comments.
can I ask Ms. Anderson a question? This is Emma.
Sure.
So, Ms. Anderson, can you hear me?
Yes.
So my question to you is, now that the house has been removed, would you say that flooding is better, worse, or about the same as before?
When I really can't say. Now, I don't live there. It's rental property. And I know it's you know, it's still not perfect by a long shot. But then I just can't really say whether it's worse or better. Sorry.
Okay. Thank you. Thank you.
All right. Thank you, Mrs. Anderson.
You're welcome.
All right. Then let's move on. Staff, is there any other comments closing comments you'd like to make?
No.
Mr. Patterson, is there any comments that you'd like to make? You have the final word, and please confirm that what I said was correct.
Yes, I appreciate all you said. It was definitely on point with where I'm coming from with all this, and total agreement. So thank you for that.
And you have any final closing comments for the board?
I think not. I think you've covered it on and everything I said before. I think should cover it as well. I think I can't think of anything else to add.
All right. Thank you. Are there any questions from the board, the board for the staff or for Mr. Patterson before we close the hearing?
I have a question for Mr. Patterson.
Sure.
Mr. Patterson, have you given any thought to addressing these drainage issues? Is there something that you could do on, I know other properties have had this issue, some kind of drainage on your side of the property that would help alleviate some of this flooding? Have you given any thought to that?
This is the first I've heard of it, so I was not aware that there was a problem. Now that I'm aware of that, I will certainly keep an eye out to see where the flooding is taking place and what can be done to alleviate it. I've not been able to. I've owned the rental property before I demolished the walls and the roof. It was a rental property for approximately 2 years. So there was a tenant staying there with her family, and I never received a call. Not once did I receive a call that there was any type of flooding on the property or in the property. There was no water issues at all. So this is a surprise to me to hear that there's a problem. Of course, if it's happening on another property, that may be why I'm not aware. If it's just coming from my property onto someone else's property, but I can certainly look into seeing what can be done to help that. I mean, water has to flow downhill. It has to keep on going down. If there's a hill there and the water has to go somewhere, it has to flow. But if it can be controlled somehow to alleviate flowing all on the same spot and be more dispersed, I'm more than happy to try to figure out a plan with that and a way to make that better for the neighbors, for sure.
Well, I would appreciate that at least you are open to looking into it.
Yes.
I realize that if you weren't aware of it, but on your property, there probably wouldn't have been, because
Sure.
it flows off of your property down. I'm not talking about something very, very expensive, a small burn or something that just causes the water not to flow quite so quickly downhill. I would ask that you give that some consideration as you move forward and re-landscape the yard.
Yes.
Okay, that's all I had. Thank you.
Thank you.
All right. Then I'll go ahead and close the hearing, and we'll start deliberations. Let's start with you, Mrs. Dryden.
Well, I'm encouraged that we're using only the existing footprint, and I can understand why he's asking for this variance so he can be in compliance. But it's been out of compliance since what they said, the 1940s. So I think this is a legitimate request. He's not asking for anything untoward here. He's just trying to get everything in compliance with the original footprint of the house.
Okay, Miss Allen.
So I might need some help here, but the original footprint was out of compliance, right?
Yes, it was built, well, it was built in 1946 before zoning ordinance was in place. And then when the zoning ordinance came in place, it's zoned R5, and the house that was built on that property encroached into the rear yard by the 17 feet that he's requesting, just because that's where the house was put on the property. And then the property envelope, based upon the setbacks through the zoning ordinance, are not that large. So there's really no other place for him to move the house within that envelope other than the same footprint.
So I guess my question is, he got grandfathered because the house was there prior to the zoning ordinance coming in effect. But when he tore the house down, if I'm hearing it correctly, he loses that grandfather experience.
Yes, once he removes the frame, then it gets down to a slab, then or the foundation. Then the conforming non-conforming goes away, and then he has to meet the current standards.
So is what he is proposing doesn't meet I suppose it doesn't meet the current standards because he wouldn't be here asking for a zoning adjustment.
That's correct. Once he took the framing down, then it became a non-conforming structure because the foundation was encroached inside the current zoning setback, rear yard setback.
And that's what gives me some heartburn. I mean, maybe he got bad advice about kind of his process and taking it down, but I've got some heartburn about putting him back into, calling it conforming when really it isn't, now that the structure is gone.
Well, it will be if we grant the variance. If we don't grant the variance, then he can't build the building back.
Yeah, that's the point that I'm making, is that we're allowing him to be.
But these are all over the city. I mean, neighborhoods that were constructed well before the zoning ordinance came into effect all have these type of situations. And they only come in front of the board when they do an extensive renovation, or they do a tear down and rebuild. And that's when they come in front of us because they can't do it without the variance.
If you look at the size of I'm looking at the size of the lot. The dotted lines are actually only the size of the lot that he could build on because of all the setbacks from the front and the back. So
from the side, yes.
Yeah, basically have to build a triangular house on that piece of property. And it's through no fault of his own that where the house was, because there was no zoning in 1947. And I don't think he should be penalized. I don't see how he could build a house on that little bitty triangular lot that the city is now, and that's only the acceptable land use. And basically it's unusable land if you don't permit him to build on the existing footprint. That would
I can appreciate where you both are coming from. I appreciate where you're coming from, and I received that. He had some other maybe alternatives. I didn't ask him this question, other than tearing the house down and starting all over. Maybe there were some improvements so that we wouldn't be re-granting him or re-grandfathering him. But I received your feedback. That's all I have.
Okay, well, yeah, he said that when he was going to renovate it, but when they got into the renovation, it was the materials were too far gone to use, and because it was too rotten, the wood was rotten, and the bricks were rotten, so they needed to just take it down to the slab and start back. But
Okay.
all right, Mr. Welch, any comments?
Yes, being that did we get the answer to the size of the new home? I know you said you was gonna ask him that question, but being that it's gonna be within the same footprint, I mean, I have no problem,
Yeah, the house is going to be within the same footprint, and then there's going to be a small addition that's shown on the government exhibit 6, which is within the existing setbacks,
Right.
which
So
we don't have any purview over because it doesn't need anything from us to do that addition.
Right. So to me, if it being that's going to be on the same footprint, there's nothing that's massive. I have no problem granting that.
Okay, Mr. Brown.
I think looking at where the new structure is going to be going within that same footprint, I'm inclined to grant this variance. Yeah, I'm inclined to grant the variance just based on the footprint right now, but I'll leave it at that.
Okay. Yeah, I agree with all of you. If he was expanding the footprint, I would have questions, but putting it back on the same footprint with a small addition within the existing setbacks, I think it's just getting it into conformity, getting it into existing conformity with the existing ordinances. So I don't see an issue with it. So is there a motion?
I make a motion to approve the variance request.
Okay, thank you. All right, we have a motion by Mrs. Dryden, a second by Mr. Welch. Do a roll call vote. Mrs. Dryden.
Yes.
Mr. Welch.
Yes.
Miss Allen.
Yes.
Mr. Brown.
Brown, yes.
Sanderson, yes. Is approved. All right, let's look at the findings of fact and conclusions of law. I didn't see anything.
I make a motion to accept the findings of fact for this case.
Second.
We have a motion by Mrs. Dryden, a second by Mr. Brown to approve the findings of fact and conclusions of law as written. Do a roll call vote. Mrs. Dryden.
Yes.
Mr. Brown.
Brown, yes.
Miss Allen.
Yes.
Mr. Welch.
Yes.
Sanderson, yes. Those are approved. We have one last piece of business to do. We need to approve the July meeting minutes that were sent out. I didn't see any changes when I reviewed them.
Motion to approve the July meeting minutes.
I second.
I have a motion by Mr. Brown, a second by Mr. Welch to approve the July meeting minutes. Mrs. Dryden.
Yes.
Mr. Welch.
Yes.
Mr. Brown.
Yes.
Sanderson, yes. Those are approved. I'll go ahead and adjourn. Is there any other business? Andrea, Max, Chad?
No, Mr. Chair.
All right, then I'll go ahead and adjourn the meeting. Y'all be safe and stay healthy, and hopefully at some point, hopefully in the near future, we can get back to an in-person meeting.
Sounds good.
Thank you.
Thank you.
Guys.